All right, thank you, Steve. Um, Good morning, everybody. Welcome to the April 17th, 2026 California Board of Behavioral Sciences Policy and Advocacy Committee meeting. My name is Chris Jones. I'm the chairperson of the committee. Before we convene, I would like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing the board's laws. Where protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. The committee will meet by teleconference in accordance with Government Code Section 11123.5. Committee members will participate remotely from private non-public sites. The public may participate remotely or in person at DCA headquarters at 1625 North Market Boulevard, Suite S102, Sacramento, California, 95834. I will announce when we are accepting public comment on the various issues, and the meeting moderator will open the lines as appropriate. Each commentator will have 2 minutes to comment. We have a very long agenda today, so brevity would be appreciated. It should also be noted that we will not be addressing agenda item number 11. Moderator, would you please provide the audience with instructions on how they may participate during the meeting at the appropriate times?
Hi, this is the moderator. So if you would like to make a comment on any agenda items throughout the meeting, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are on a mobile device, the hand icon may be behind 3 dots, other options. And if you have joined us by calling in, you can press *3 to raise your hand. Requests to comment will be called upon in order they are received. And once your name is called out, you'll see a prompt on your screen to unmute yourself. For members of the public joining us via dial-in, you can press *6 to unmute yourself as soon as you see the unmute request on your screens. You'll have 2 minutes with a 15-second warning to make your comment, and we'll also be displaying instructions throughout. Thank you.
All right, thank you, moderator. I would now like to call the meeting to order and ask Christina to call roll to establish a quorum.
Good morning.
Good morning.
John Sovek? I didn't hear you. One more time, John.
Here.
Thank
Present.
you. Kelly Ranasinghe?
Present.
Chris Jones?
Here.
Wendy Strack is not with us yet, but we have a quorum.
Thank you, Christina. Next, board staff, would you please introduce yourselves?
Good morning, Steve Sodergren. I'm the Executive Officer of Board of Behavioral Sciences.
Hi, Roseanne Helms, Legislative Manager for the board.
Shelley Ganaway, Board Counsel.
Marlon McManus, Assistant Executive Officer for the board.
Sarita Risso, Special Projects and Research Analyst for the board.
Christina Kittamura, Administrative Analyst for the board.
I'm on remote, and this is Christy Berger, Regulatory Manager for the board.
Thank you, and that's it.
All right, thank you. Now it's time for the public to introduce themselves if they would like. This is voluntary. Is there anyone in the audience that would like to introduce themselves?
There is.
Good morning. Good morning. Shanti Ezrin, California Association of Marriage and Family Therapists.
Morning, Shanti.
And that's it for in-house.
Is there anyone else in-house besides Shanti?
No, that's all.
Okay, thank you. Moderator, is there anyone online that would like to introduce themselves?
Yes, we do have a couple of raised hands. I see Bindu. You're going to be seeing an unmute request on your screen. Click on that and you'll be able to unmute yourself.
And Chair Jones, can we just announce that Wendy has also joined, please?
Yes.
Thank you.
Welcome, Wendy Strack.
Good morning.
Good morning.
Hello, good morning. This is Bindu Mukamla, Policy Manager with the National Association of Social Workers, California chapter. Glad to be here. Thanks.
And thank
Is
you
that
for
all we
your
have
comment.
remotely joining us?
We do have a couple of other raised hands.
Okay, thank you.
So next is Sarah Carrasco. I'm going to send you a request to unmute.
Good morning, everyone. Sarah Carrasco, William Jessup University, Licensure and Compliance Specialist. It's a pleasure to be here.
Thank you. And our next introduction is Ben Caldwell. I'm sending you a request to unmute.
Good morning, everyone. Ben Caldwell, licensed marriage and family therapist.
Wonderful. Thank you so much. And our next introduction is from Roya. Roya, I'm sending you a request to unmute.
Good morning, everyone. My name is Roya Candia. I'm an associate marriage and family therapist.
Thank you. And Gina Castro Rodriguez. And I've sent you a request to unmute. And it might appear, I've heard this on some machines, it appears as a new browser tab.
Sorry about that. Good morning, everyone. Dr. Gina Castro Rodriguez. I'm with the University of San Francisco.
Wonderful. Thank you so much. And I believe that is all of the introductions. That's all the raised hands. So we'll turn the meeting back to you.
All right. Thank you, moderator. Welcome to everyone who's attending today. Thank you for being here. Our first agenda item is discussion and possible approval of the January 15th, 2026 committee meeting minutes. Do any of our committee members wish to remove or edit any items from the consent calendar? Nope. All right. Do I have a motion to approve the consent calendar?
This is John Sovak. I move to approve the consent calendar.
Do I have a second? I think that's Kelly.
I'll second.
Thank you, Kelly. Are there any comments from our in-person attendees?
There is not.
Any comments from our online participants?
This is a moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your WebEx screen. And if you are joining us through a login, through a phone, you can press *3 to raise your hand. We are displaying instructions and we'll give you a moment. I see no raised hands. I return the meeting back to you, Chair.
Thank you. Christine, would you please take the vote?
Yes. Chris Jones,
Yes.
Kelly Ranasinga,
Yes.
John Sovak,
Yes.
Wendy Strack.
Yes. Sorry.
Motion carries.
All right. Thank you, Christina. Next on the agenda is the discussion and possible action to make recommendations regarding possible statutory amendments, pathway to license requirements. Roseanne, would you please give us the overview?
Thank you, Chris. So AB 1598 is our board-sponsored bill this year. It represents our first step in restructuring and modernizing the licensing process. It does things like increase the time supervised experience hours are valid from 6 years to 7 years. It is, allows a registration number to be valid for 7 years instead of 6. And it allows associates with a subsequent registration number to request a one-time 2-year hardship extension. And it modernizes the exemption language for faith-based counseling by clarifying when faith-based counseling is exempt from licensure. And then on that last piece for faith-based counseling, we had to make an amendment related to that in the bill just went through this past week, its first committee, the Assembly Business and Professions Committee, and we had some concerns about the exact wording from the psychology and medical board professions. So the amendment that we had to make to avoid opposition was in 4980.01 for LMFTs, 4996.13 for LCSWs, and 4999.22 for LPCCs. And the concern was what we had done when we had made the the pastoral counseling amendments. That amendment was, that language in current law was tangled up with the amendments for exempting our certain other professionals from our practice acts, including people like medical doctors, psychologists, registered nurses. So when we tried to untangle that language, we noticed that it was different for each profession, and we generally don't like that. So we tried to make it more similar, and we sort of used the exemption law for social work as the model because it was the most clear and concise. However, that had something in it that prohibited the use of the term psychosocial. It was kind of thought among discussion that it should be we should also say psychotherapy. Well, the medical profession and the psychologists rightly pointed out that they can indeed practice psychotherapy. So we can't have a prohibition in there for them practicing psychotherapy, obviously. So we needed to amend that language. And so the amendments you see, and I will note that they're not in red as the memo says, because I've included the bill as amended yesterday, is basically we took those amendments out and tried to put the law back to it. We're not for the professional exemptions. We're not trying to make the 3 practice acts similar anymore. We're just letting them each have their sort of own exemptions as the laws have evolved over time. So we're not trying to go for continuity anymore, because there's a lot of little differences in there that are really important to the stakeholders, and they've kind of evolved that way for a reason. So we're putting things back as they are, carving out one piece of language that was in LMFT and LPCC law about medical, I believe it was medical and lawyers, that was tangled up with the pastoral counseling. So that's been split out separately, but otherwise we're trying to just go forward with just the pastoral exemption and not make any amendments to any of the other ones. So hopefully that makes sense. The amendment appeared in print on Wednesday. And so, but since it is technically a substantive change, even though we're trying to put the language back to as close to as it was before as possible, we still need to get board approval for it. And I'll open it back up to Chris.
Thank you, Roseanne. Any comments from our committee members? Nope, sounds straightforward. Would someone like to make a motion?
I'll make.
Do you want me to read it?
Oh, go ahead.
Oh, yeah,
Yes, please,
sure.
Roseanne. Always. Yes.
Yeah.
The motion would be to direct staff to make any discussed changes, which I'm not hearing any non-substantive changes, and bring to the board for approval as an amendment to AB 1598.
I'd like to make that motion, Mr. Chair.
Thank you, Wendy.
I will second that motion.
Thank you, Kelly. Any comments from our in-person attendee?
Yes.
Good morning, Shanti Ezrin with CAMPS. Roseanne, just really want to appreciate all the work you've put into this bill, and also for working with and being so responsive to the different stakeholders that reached out. At CAMP, we're just going to take a look at the recent amends that you pointed out that were in print a couple days ago, and then from there assess our position.
Thank you, Shanti. Any comments from our online participants?
Hi, this is a moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are joining us from a mobile device, the hand icon may be behind the 3 dots other option. We are displaying instructions and we'll give you a moment. I see no raised hands. I return the floor back to you, Chair.
Thank you. All right. Christina, would you please take a vote?
Yes. Chris Jones,
Yes.
Kelly Ranasinga,
Yes.
John Sovek,
Yes.
Wendy Strack.
Yes.
Motion carries.
Thank you, Christina. Next on the agenda is the discussion and possible action to make recommendations regarding stipend and loan repayment allowances and submission of 1099 tax forms. Sarita, would you provide us with an overview? Or is it
Hi.
Sarita or Sarita,
Yeah.
right?
Yes.
Okay.
Yeah. Hi, good morning. So
Good
just to
morning.
provide a little bit of background regarding our current Practice Act, while gaining hours of experience in supervision, our current Practice Acts require a trainee, associate, or applicant for licensure to only perform mental health and related services as an employee or volunteer and not serve as an independent contractor. Upon application for licensure, an associate is to submit either copies of their W-2 tax forms for each year of experience claimed if they are employed, or a letter from the associate's employer if the associate served as a volunteer when gaining experience hours. In the past, there were occasions when applicants would submit to the board a 1099 tax form with their employment documents upon application for licensure. And a submission of a 1099 tax form usually indicates the applicant served as an independent contractor when gaining hours of experience, which is not permitted. However, there was past statute that specified trainees, interns, and applicants who provided volunteer services and received no more than a total from all work settings of $500 per month as reimbursement of expenses in any lawful work setting other than a private practice, were considered employees and not independent contractors. The subject of stipends and educational loan repayments was brought up in prior discussions within the former supervision committee. This was in response to the staff's proposal to remove the $500 monthly reimbursement limit from statute. During these past discussions, committee members in the past supervision committee and staff noticed that an awarded stipend or a loan repayment would occasionally be reflected on a 1099. And at the time, staff were also becoming aware of stipend and loan repayments issued to interns, associates, and applicants as an incentive for working in an underserved area or from programs designed to encourage demographically unrepresented groups to enter the profession. So an exception for stipends and loan repayments were also proposed to be added to the statute. The work of the supervision committee resulted in amendments to the board's practice acts for supervised experience and supervision practices that included the removal of this from statute of the pertaining to the $500 monthly amount for the reimbursement of expenses incurred. And additionally, clauses referring to stipends and educational loan repayments were added to the LMFT, LCSW, and LPCC practice acts that are currently in place. So the current clause in statute states that a trainee, associate, or applicant for licensure who receives a stipend or educational loan repayment from a program designed to encourage demographically underrepresented groups to enter the profession or to improve recruitment and retention in underserved regions or settings are to be considered an employee. The board may audit an applicant who received a stipend or loan repayment, in which case the applicant would have the burden of demonstrating that the payment received was for the specified purposes. Since its enactment, staff have occasionally identified misinterpretations of the clause by applicants for licensure. In some instances, applicants cite the clause, claiming that since they work in a rural or underserved setting, their workplace should issue a 1099. However, that wasn't the intent of the clause. The clause was to acknowledge stipends and educational loan repayments issued from programs designed to encourage demographically underrepresented groups to enter the profession or to improve recruitment and retention in underserved regions or settings. Staff have noted that there are several types of 1099 IRS tax forms, including the 1099 form for non-employee compensation. And that particular 1099 form is issued if an individual received at least $600 for example, for the 2025 tax year. If the 1099 NEC form is issued if they receive at least $600 in that tax year for rents, prizes, awards, or other income payments. Currently, supervised experience hours are not accepted if a 1099 is submitted as documentation, unless the applicant for licensure can demonstrate that the 1099 was for an awarded stipend or loan repayment. So given these instances of 1099 submissions issued to the board or submitted to the board, staff proposed that either the language in the clause be either clarified removed, or regulations should be added to specify what constitutes acceptable proof that a 1099 was for a stipend or loan repayment. So to gain a clearer understanding of the various stipend and loan repayment programs that are offered by organizations at the federal, state, and county level that seek to encourage and demographically underrepresented groups to enter the mental health profession, as well as strengthen the recruitment and retention of mental health professionals in underserved areas, staff retrieved the following information, which are outlined in more detail in attachments A through D. Right now, I'll just briefly highlight some of the main points of each loan repayment and stipend program. So I'll first start with the Licensed Mental Health Services Provider Education Program. It's a loan repayment program through the California Department of Healthcare Access and Information, or we just refer to as HCI. This is intended for psychologists and at the associate level, at the associate and licensed level, marriage and family therapists, social workers, and professional clinical counselors. So under this program, awardees are to provide at least 32 hours per week of direct care in a qualified facility in California for 12 months. Examples of a qualified area and approved sites under this program include a health professional shortage area, a publicly funded mental health facility, a public mental health facility, and a nonprofit mental health facility that contracts with the county entity to provide mental health services. And it's going to be referenced later, but I just wanted to note a health professional shortage area, or HPSA, is defined as a geographic area or population or facility that has a shortage of primary, dental, or mental health care providers. So under the Licensed Mental Health Services Provider Education Program, once the service obligation is complete, awardees receive their loan repayment that can be applied toward their outstanding educational debt. Under this program, we were informed that through HCI that HCI does not issue 1099 tax forms to its awardees under this program. Another loan repayment program through HCI is the Medi-Cal Behavioral Health Student Loan Repayment Program. This is created to help grow California's healthcare workforce by paying off student loans for behavioral health professionals. Requirements under this program are similar to HCI's Licensed Mental Health Services Provider Education Program, where the service obligation includes providing direct care to clients and facilities that serve Medi-Cal and uninsured patients. The grant guide for this particular program, this is for the grant year 2025, which I believe is passed, but the grant guide, it does provide additional information which can be found under attachment B. And at the federal level, the National Health Service Corps Loan Repayment Program through the Health Resources and Services Administration aims to recruit and retain medical, nursing, dental, and behavioral health clinicians in eligible communities of need that are designated as a health professional shortage area, or HPSA. This program awards eligible primary care providers financial assistance toward repayment of their outstanding loans. In return for financial assistance, participants in this program have to commit to providing primary care services in underserved populations. Eligible care providers under this loan repayment program include LCSWs, MFTs, and LPCCs. The Los Angeles County Department of Mental Health offers a stipend program where one of the objectives is to, quote, provide a financial incentive to attract well-trained linguistically and culturally competent students who will serve communities and clients who have been historically underserved due to geographic location and cultural and linguistic barriers. Under this program, each year, a stipend is awarded to selected students that are enrolled in an academic program that leads to a mental health degree. Students who are awarded a stipend under through the Los Angeles County Department of Mental Health through their program are required to commit to a 1 year of full-time employment in a clinical capacity at a facility that is operated by the LA County Department of Mental Health or at an agency that is contracted by LA County Department of Mental Health. And lastly, the San Diego Pay It Forward program is designed to attract and retain public behavioral health workers and address the behavioral workforce shortage in the San Diego region. Eligible students under this program can receive loans with 0% interest to cover tuition, fees, and living expenses while enrolled at a behavioral health education program. Those programs are mostly like in the San Diego area. The program brochure that is attached in attachment D provides additional details regarding this program. So with this information, staff recommend conducting an open discussion on the proposed options related to the clauses on stipends and educational loan repayment programs. These are outlined in Business and Profession Code sections 4980.43. Sorry, let me start that again. 4980.43.3H, 4996.23.2G, and 4999.46.3I. And the proposed options are either to, 1, clarify the language of the clauses in statute, 2, delete the clauses from statute, or 3, run regulations that specify how an applicant would demonstrate they received a stipend or loan repayment on IRS tax form acceptable by the board. And we'll turn it back to you guys.
Thank you, Sarita. Any comments from our committee members?
Hey, this is John Sovek. Sarita, a question that I have for you is I've been reading through this and I find it incredibly overwhelming and confusing. How often are we seeing this showing up? And are we hyperfixating on a problem that's existing in a large bit of our population, or is this a very small piece of an exception that we're trying to address here?
I would say it's more the latter. It's only when I followed up with staff, because our licensing unit staff are the ones who've encountered this. And from my follow-up, it's very rare that it happens. It's on a few occasions. But when it has happened, it made us realize that the language probably either needs to be more clear, or since it's not as a case, it doesn't happen as often, maybe, delete it or just make the language a little bit more clear.
Because the thing that I'm concerned about is like HCI says they don't provide excuse me, 1099s of any form. So each agency, as you're going through them, provides different types of response, and some don't provide any response at all. So is there any way that language can even be written in a way that clarifies and addresses every case we're trying to cover here? Or do we find ways to work with staff and the applicants to, work on these specific cases rather than trying to make an overall policy change?
Well, with the language, considering that there's various, that's why I try to include some of the various different, stipend and loan repayment programs, because some of them are at like a government level, but some of them are also nonprofit. So the language maybe, if we were to go that route, would be maybe to just specify the type of program, whether it be a governmental or nonprofit agency.
And as someone who's worked in the nonprofit sector, I would see so many challenges coming up with trying to get all of the correct information from a nonprofit as someone who's applying for their license. I could see it being a really rough thing for someone to have to run through.
Mm-hmm.
I guess my question would be what is the easiest way to finesse this so that it gives access to those who want to work in underserved communities the ability to get that repayment. So kind of to John's point, it was a lot of information. So what is your recommendation on the most efficient way to to solve this problem?
Well, because really the where we kind of come into play is when we receive the 1099 form, which we don't normally accept for documentation for supervision hours. So either, I know the route I'm thinking, but I don't know. Yeah,
Okay.
because I have ideas, but I don't know if we all have the same.
The main concern we have on the staff level is that we've had people, trying to argue that because they work in an underserved setting, that they can have a 1099 count. And we don't want to, we can't accept 1099s generally. And it's even with AB5, there's a lot of laws now that where employers can't be issuing a 1099 anyways. So I think that we don't really want to delete the language because we still want the opportunity for somebody that has one of these programs and for some odd reason has to get a 1099. We want to have a clause for them because otherwise it risks them losing their hours, which we don't want to do if it's legitimate. But we need the law to be a little bit more clear so somebody couldn't successfully argue and win that they can just get issued a 1099 because they're working in this setting. That's not the intent. So I think that our suggestion would be to clarify the clause a little bit in statute, just finesse it a little, so that if there's some criteria,
yeah,
so we could work on language, maybe that if it's through a government or a nonprofit program, and it's not like a payment by the work setting for the services, something like that, so that we're really narrowing down for these particular settings, that particular use is allowed, but it's not meant to be a broad general use.
Yeah, that's kind of what I was thinking. And that's why I included in the memo there's a link that includes the different types of 1099 forms. So that way, if we do go that route of clarifying or running regulations, it kind of gives us an idea as to like, if we're going to go and accept 1099s, then we might want to specify the particular 1099 form, since there's which I learned, I didn't know until I started doing research, that there are different 1099 tax forms. I thought it was just a 1099, but apparently there's one for interest, there's a miscellaneous one, so.
So I think the staff recommendation would be to work on just drafting some language to sort of modify and clarify that subsection a little bit for the next meeting. And then we can go from there and talking about if that works, whatever we propose is acceptable, or if it needs to be modified further.
Yeah.
That would.
Oh, sorry. As well as clarify, the type of program, because the language in the clause right now, program is just kind of vague. But in looking at the various types of programs, they're at, different levels of government or they're nonprofit. So if that's the route we do, kind of clarify the type of program as well as the type of 1099 form, if that makes sense.
Yeah. Kelly, you got a comment?
Yeah, Roseanne, do we need a whole clarifying regulation for this, or can the board just issue a policy memorandum?
No, we need to have, I don't know that we necessarily need to have a regulation. That we'll have to talk about with legal, but I think that we can start by trying to amend the statute. We can't just have a policy because that would be an underground regulation. It has to be specified. And I think the way that it's written now is vague enough that, somebody could argue, it's too vague right now. We need to clarify it further.
Okay, then I would move that staff develop language to clarify the existing regulation in question and bring it before the next policy and advocacy meeting.
Okay, we have a motion. Do we have a second?
I'll second.
Any further discussion from our committee? All right, any comments from our in-person participant?
Yes.
Good morning again, Shanti Ezrin with CAMPT. Just wanted to start by thanking Sarita for just the vast amount of research you put into this. And at this point, no concerns with the staff's proposal. It's really important that we find ways to support and allow these providers to get the financial assistance that they need as they work to further their education on their way to licensure. So as it relates to the three proposed options that staff listed out, we'll definitely take this back to our team to review and then circle back with our feedback, certainly acknowledging the concerns heard by committee members today and also staff's input that clarity and clarifying the language, needing to finesse that a bit is needed. So we'll be circling back soon. Thank you.
Thank you, Shanti. Any comments from our online participants?
Okay, this is the moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your WebEx screen. And if you are a call-in user, you can press *3 to raise your hand. We do see a raised hand. Dr. Lisa, I'm going to send you an unmute request. Please click on that to make your comment.
Hi, good morning. Can you hear me?
Yes, I can. Please go ahead.
Awesome. Okay, I'm Dr. Lisa Weninger. I'm an LPCC in California. I'm also licensed in a variety of other states, and California is incredibly restrictive in so many ways that restricts the ability for pre-licensed clinicians to get paid a fair wage. Sarita, I want to thank you so much. I actually understood everything that you shared because I am such a policy geek. I actually have 2 years ago founded a nonprofit called Resident Equity in California that has been designed as a corporate entity to support exactly the problems that are baked into the California Legislative Code in terms of trying to offer practicum experiences for students in counseling programs, especially, but any mental health program, to not only receive high quality supervision, hopefully, but also to find a way to pay them. And our restrictions around 1099s and requiring students and associates to be W-2 employees, I understand the rationale for that, but it severely restricts our ability to help our students get through these programs. So I was actually under the impression that as a nonprofit, I could create a program to specifically around this rural mission, this exception that was in these laws. And today it sounds like maybe I can't. So I'm stumped on how I can help support payment to these clinicians that are working so hard in their training environments. So I want to say that I'm very invested in, no pun intended, in whatever you're doing here. And I'm keenly interested, and I would love to be able to participate if I could. Anyway, I appreciate that this is on the agenda.
Thank you. Any other comments from our online participants?
I see no other comments. I return the floor back to you, Chair.
Thank you. All right, Christina, would you take a vote?
Yes. Chris Jones,
Yes.
Ellie Ranasinghe,
Yes.
John Sovek,
Yes.
Cindy Strack.
Yes.
Motion carries.
Thank you, Christina. Next on our agenda is the discussion and possible action to make recommendations regarding Assembly Bill 1558, Arumbula, Uniform Emergency Volunteer Health Practitioners Act. Roseanne, would you please give us the overview?
Yes, thank you. So AB 1558 would enact the Uniform Emergency Volunteer Health Practitioners Act, and its goal is to standardize how volunteer health practitioners are registered, verified, and deployed during declared emergencies in California. It defines what constitutes a volunteer registration system, defines scope of practice rules, and provides the State Emergency Medical Services Authority, which we're going to call EMSA for today, the authority to regulate volunteer deployment and coordinate during emergencies. So in terms of a little background, current law establishes a federal emergency management assistant compact for the purposes of providing mutual assistance between states managing an emergency disaster that's declared by the governor. And it establishes EMSA here in California to develop planning and implementation guidelines for emergency medical service systems and to provide technical assistance to states and counties and cities in California. A little bit of background on this bill. The author is running it because they state that California faces delays in deploying volunteer health practitioners during emergencies without a clear law. under the current system, volunteers can't be deployed until the state formally approves them to serve, and that can take time and delay response efforts. And in the recent LA wildfires, they had a workaround, but officials made it clear that it needs to be requested and approved separately for each future disaster. So the author and sponsor states that the case-by-case approach is uncertain and it creates a slower emergency response. And so this bill is actually a model bill that was that's from the, I believe it's called the Uniform Law Commission. And so several other states have adopted it. And so what it does is it establishes the act and it sets certain requirements for various things. So it sets requirements for a state compliant volunteer health practitioner registration system so that those are in place. And to be a registration system, you need to either be part of a federally authorized program under the Public Health Services Act, or you need to be operated by a disaster relief organization, a licensing board under DCA, which is interesting, a national, state, or regional association of licensing boards or health practitioners, or a health facility that provides inpatient and outpatient services, or a government entity, or you can be designated by EMSA as a registration system. So it kind of sets forth that process. The registration systems accept applications for volunteers before or during an emergency. They provide information to EMSA to confirm standing and accuracy of the health practitioners. And then during the declared emergency, it permits EMSA or its agent to confirm whether the volunteer health practitioners in the state are registered with a state compliant system. The bill also defines a volunteer health practitioner as a health practitioner who provides health or vet services in this state, whether as a let me restate. As somebody who provides health or vet services, whether or not they're compensated, they can't already have an existing relationship and be working here as part of a organization. The bill allows EMSA to regulate volunteer health practitioners for including the duration of their practice, the geographical areas where they're working, the type of practitioners permitting, and anything else necessary for the emergency. The host entity has to coordinate with EMSA and comply with all laws. And then a volunteer who is registered with the registration system and is licensed in good standing may provide services during the emergency. They have to adhere to their scope of practice for a similarly licensed profession in this state. And they must not provide services that are outside their own personal scope of practice. The bill also permits the applicable licensing board to restrict or modify the health services that the volunteer health practitioners may provide. And it prohibits a volunteer health practitioner from being found to have engaged in unauthorized practice unless they have a reason to know of any limitation, modification, or restriction that a similar licensed professional in this state would not be permitted to provide. The reason to know is defined as that they know the modification or limit or restriction exists, or they should have reasonably known. And finally, the bill gives the author, or not the author, the licensing board certain powers and duties. It can impose administrative sanctions on a health practitioner licensed in this state for their conduct outside of the state. And it can propose administrative sanctions on a practitioner not licensed in this state for their conduct in response to an emergency in this state. And the licensing board must also report any sanctions that it imposes on a practitioner licensed in another state to that person's licensing board in all other states. In terms of analysis and further discussion, 22 other states have passed legislation similar to this. I've provided a link in the analysis to the Uniform Law Commission that summarizes where the progress of where it's been adopted in other states. In terms of past waivers in this state, during COVID, certain health providers licensed out of state were able to apply to EMSA for a temporary authorization. That allowance ended in February 2023. And during that time, several hundred equivalently licensed master's mental health professionals were authorized by EMSA to provide services in California. Again, in 2025, there was the wildfire emergency, and EMSA again provided temporary practice authorization for healthcare providers to assist with that disaster. And during that time, EMSA provided temporary authorization to 9 master's levels out-of-state mental health professionals, most of whom were working for the Red Cross. One thing that I noted with the bill, and actually I'm going to go through, I have 3 points of kind of things that I noticed with the bill that are points of concern. I actually provided this these concerns to the author's office, and they had the Uniform Law Commission attorney respond. So I'm going to read each of the 3 concerns, and after I do that, I'm going to actually provide her response to each one. And the response is from Sarah Cannon, who is legislative counsel with the Uniform Law Commission. So the first concern that I had raised was the provision of practitioner information to the applicable licensing board, stating it's unclear whether EMSA would be required to relay the information about the practitioners to the applicable licensing board. They did provide this information to the board during the 2 previous emergencies, but the board should discuss whether the provision of this information should be a requirement. And her response to that was that the bill is intentionally drafted to preserve flexibility needed to respond in a wide range of emergencies, including catastrophic events where normal communications may be disrupted or unavailable. And so for that reason, it does not impose a rigid requirement that EMSA relay information about practitioners to a board during a declared emergency. But she does note that nothing in the bill prevents EMSA from providing that information. They provided it in the past, and based on history, they believe it would be likely to continue that practice in future emergencies. So that's the first concern. The second concern that I had raised is in Government Code 8599.57A of the bill, the subdivision states that a volunteer health practitioner practicing here must adhere to the scope of practice for a similarly licensed practitioner in this state. I had a concern that similar is somewhat vague, especially with our professions where there's a lot of mental health professionals nationwide that not all have a equivalent license in a state, but may have a similar one. So I suggested that the term similarly be replaced with equivalently. The response to that was that the Uniform Law Commission would not take issue with that proposed change. And then finally, I had a concern in Government Code 8599.57E about unauthorized practice. It prohibits a volunteer that is engaged in unauthorized practice from being found to engage in authorized practice unless they had a reason to know of the limitation, modification, or restriction under the Act, or unless they had a reason to know that a similarly licensed person in the state would not be permitted to provide those services. From a consumer protection standpoint, there's a concern that a practitioner practicing out of California could simply claim ignorance of the fact to avoid accountability. So I suggested that the bill be amended to require all volunteer health practitioners to attest that they have reviewed and will comply with the California scope of practice prior to providing any services. So the response to this was somewhat lengthy. They noted that the volunteer practitioners are required to provide care consistent with California's scope of practice and any agency-imposed limitations wherever possible. The provision, though, reflects the reality that it's intended to operate in emergency conditions, including catastrophic situations where communications may be disrupted, information may be incomplete, and rapid deployment may be necessary. And so in those circumstances, a volunteer practitioner might not be able to confirm every limitation or modification or restriction. If they face administrative sanction for acting without perfect information, they might be discouraged from serving at all. but it does not allow a person to avoid accountability merely by claiming ignorance. The volunteer health practitioner is not protected if they knew or reasonably should have known that a limitation applied or that the services were outside of what a similarly licensed California licensee could provide. For example, if they were informed that a certain services are not permitted or that they fall outside of permissible practice, they would be subject to sanctions. And they note that EMSA also has authority under the bill to regulate the types of volunteers who can practice, and they could require volunteers to review and attest to applicable California scope of practice requirements before providing services, but making that a mandatory requirement in every emergency could reduce the flexibility needed in chaotic conditions. So that is the concerns and then the responses to the concerns. Is written, just to note, the bill does not have a significant fiscal is written. However, there is a provision of the bill that gives the licensing boards the ability to qualify as a volunteer health practitioner registration system if they choose, but it's a permission, it's not a requirement. If the board were to choose to do that, that would be a significant fiscal impact. It would need to be costs to develop and implement the application process, as well as a continuous workload to review applications, enter information, keep it current, and respond to inquiries. So that particular feature would not be absorbable within existing resources, but it's not a requirement as of right now. So given all of that, staff is recommending that the board consider taking either a support or a support if amended position on the bill, depending on how you feel about the various concerns raised.
Thank you, Roseanne. That was a lot. All right. Do we have any comments from our committee members? No. John.
Hey, it's John. I was just waiting to let someone else speak first. So, Roseanne, I have a question for you. In your section describing this bill on page 6.3, item number 6, during the emergency declaration allows EMSA to regulate volunteer health practitioners regarding the following. What exactly does this mean?
It means that if there's a very specific geographic area, like let's say that that the disaster is limited to like a part of a city or a certain area, they can specify that they just practice in that area. Maybe the Red Cross is deploying to a specific site. They can limit them to practice to just that site. And they can also limit how long they practice and who is practicing there. They kind of already do that now. That was done with the wildfire effort to an extent in the Los Angeles area.
Okay. So I noticed that the bill is being supported and sponsored by American Red Cross. And speaking from experience, I have been a volunteer mental health provider in their system before. And the process of getting into it is basically just a 2-day training on, hey, what's it look like when you respond to an emergency? Nowhere in the process was there any vetting of my license, my ability to provide these types of services. So my curiosity is EMSA going to maybe be stepping in and looking at that type of regulation? Because during the wildfires, I'm a survivor of the Eaton Canyon fire. We had lots of very well-meaning mental health clinicians coming in and offering like some free sessions. But the grief and loss and community experience of going through a piece like this isn't just like, hey, here are 2 free sessions, let's go on. And there was no regulation that seemed to be appearing in the community to respond to that. So is this bill going to potentially address that, not looking just at the immediate response, but also looking at what these well-meaning volunteers are doing, but in the scope of a longer term of mental health care, especially since we're here to provide protection for the people of the state of California?
I don't think that that's the long-term vision for the bill. I think I think that we are kind of part of this, but it's more aimed at more immediate medical providers like doctors, to provide that emergency on the ground care. But especially social workers, we see a lot of social work licenses do get to have gotten deployed in the past. We had several hundred during COVID. And yes, you raise a good point that mental health is more ongoing. I think that the point of this bill is to just have more of a system in place so that there are more protocols so how this happens, and to allow these individuals to be able to respond further rather than sort of having the red tape is what this is looking at.
And this still brings up the concern of, we look at scope of practice. If I'm not a trained emergency response person, how is EMSA going to be looking at that type of response if we choose to support it? And also, too, I agree with you about the unauthorized practice piece. I think there are lots of huge gaps in what could happen in that. And so that does concern me, if there's a way for the bill to tighten up how that consumer protection piece would stay out, what be put into place when we're looking at types of practice that may not be the best services for the people in these emergency situations.
All right. Thank you, John. Any other comments from our committee members?
Yeah, just a question. I mean, I think the number of the things that John just outlined can be a pretty significant concern. And, there's always a delicate balance between, being responsive in an emergency and then also providing a path that those people that are responding in the emergency are not going to harm those that they are aiming to help. So I'm not sure necessarily of whether we should support the bill as it stands, given that there are concerns. Is there I think what I've done before, sometimes you can have sort of a work with author position where we're sort of working on amendments or sort of tightening things up, but we're not really weighing in on the overall bill itself, and not necessarily blessing a particular organization and how they deploy people, but really of like, if you're going to be doing this, these are the things we'd like to see. I don't know if maybe there's a path that way.
Roseanne, isn't that kind of what you were talking about with the supportive amended position?
The supportive amendment. I mean, if the board chooses to be neutral, I mean, we could certainly provide technical support. The incentive isn't necessarily there to work with us if it's something that's hard. If we did a support if amended, that's one option. You could do an oppose unless amended. That's another option. So yeah, we would just need to outline specifically what the members want to see.
Yeah, and Chris, just for clarification, that a sort of a work with author type position is very different than a supportive amended or oppose unless amended. Those all kind of carry different contexts. But yeah, there would certainly be less incentive to listen to us if we weren't also accompanying it with a position. But I guess my concern is whether we're going to be able to get everything we might like to see in it, and then sort of how does that impact how we feel about the overall bill?
I don't know. I think we would need a specific suggestion from the board of what we would like in terms of it sounds like I'm hearing that the unauthorized practice is a concern. So I think we would need to specifically we would need a specific suggestion of what we would like to see. Like if it's a mental health professional, they need to be informed of their licensing. Maybe if it's a mental health professional, they need to be informed of the licensing boards scope of practice in the state or something like that, or they need to attest to it. That way, maybe it wouldn't affect the medical professionals that they're trying to get boots on the ground for it, but it would carve out the mental health, something like that. I don't know. I mean, I'll kind of defer to you to figure out exactly what you want to ask for, but something along those lines maybe might be amenable. They can say no too and continue on, but that might help.
John?
Roseanne, how far along are we in the process of this bill? Is it just newly being birthed, or is it moving along?
It's moving along. So I think it goes to its first hearing next week. So we'll know a little bit more what others are thinking about. It'll make the support and opposition more apparent, and we'll be able to hear after next week when that becomes public what others are saying about it. But yeah, so we could choose to delay to the May meeting as well.
Any other comments? No?
I would just say I definitely hear Board Member Sovik's comments, and they're well taken, particularly given the chaos which can ensue during a disaster. That's all I have to say.
So if I'm hearing my fellow board members, are we kind of we would like to wait till May and bring it in front of the board when we have more information? Because there are some serious concerns.
That could be an option. It might help to see if there's any public comment too before we go.
Oh, of course. Yeah.
Okay.
I didn't know. Go ahead.
I wanted to just clarify. So it sounds like most of the concern revolves around the unauthorized practice item. Is that correct?
I believe so.
Okay. So we could try to for the May meeting analysis, I could try to put together some sort of a little exemption that maybe carves out mental health professionals, so that we would have something specific to discuss whether or not the board agreed with asking for at the May meeting. Does that sound like a good plan?
Yeah, I think that sounds good. Let's get some comments from our participants. Does Shanti have anything to say?
Thank you.
Hi, Shanti here. Just really quick, thank you, Roseanne, for the bill review and walking us through the highlighted concerns. And we've jotted down the notes. Appreciate the concerns and questions from the committee members. Camp, we're still learning about this bill, and the plan is we'll take it back to our team to assess. So more information to come. Thank you.
All right. Thank you, Shanti. Do we have any comments from our online participants?
This is the moderator. If you would like to make a comment, please click on raise hand icon at the bottom of your WebEx screen, or if you are a call-in user, you can press *3 to raise your hand. We are also displaying instructions and we'll give you a moment. I see no raised hands. I return the floor back to you, Chair.
All right, thank you. John.
Hey, Roseanne. So once again, you are sitting there in the middle of working with these teams. Will you have more voice in the room if we do support, if amended, and identify some of these specific things we want to do? Or is the committee really open and there's lots of space for the BBS voice to be heard as they're still creating and changing this?
They've been pretty open. I was surprised that they went to the when I sent the author the concerns just as technical feedback. I was surprised that they had somebody from the Uniform Law Commission contact me, and she had some well thought out explanations. So that shows a good faith effort that they want to make the bill as good as possible. I can try to reach out and say, hey, this is what we're thinking. We're taking a formal position in May, and just see how they respond. You could either do some support if amended or oppose unless amended are really the two biggest sticks usually, are to poke somebody into really caring. But I think the board would need to balance that with kind of the effort in what they're trying to do and those sort of factors. But I can reach out in the interim and try. They've already said that they're open to replacing similarly licensed with equivalently. I don't know if how the committee feels about that, if that's something you want me to continue to pursue or not. They said they're open to that. I sort of feel like they gave a fair reasoning for item 4, which was the provision of practitioner to the applicable licensing board. Even though there's not a requirement to provide it to us, EMSA did provide that to us. So I kind of, in my mind, that concern, at least in my opinion, is sort of relayed. It's really the similarly licensed, which they've committed to, and then the big one is the unauthorized practice. I don't know if you agree with me on that, so let me know.
All right, any other comments? Do we have a direction committee that we're feeling? I think I would be on the side of let's try to work with the author's office to get some of the details hammered out. I think it's important that we have that there is access to mental health supports during disasters. But to John's point, we don't want to we want to make sure that the consumers are also protected. So John?
And I personally feel with Roseanne's response is work with authors and report to the May full board meeting would be a direction I would encourage.
Yeah, that seems to make the most sense. Committee, any other thoughts? Okay. Roseanne, we don't need a motion for that, correct?
No.
Okay. So do you have the direction that you need?
Yes, I do. Thank you.
Awesome. Thank you. That was, you guys have been doing a ton of work. That was a big thing. So I appreciate you.
Thank you.
All right. Where are we at? 11:08. Okay. Let's go through one more agenda item and then we'll take a break. Is that okay? We good? Okay. So next on the agenda is discussion and possible action to make recommendations. Oh, nope. Sorry. That's the one we just did. Next one on the agenda is discussion and possible action to make recommendations regarding Assembly Bill 1979, BONTA, Healthcare Services, Artificial Intelligence. Roseanne, back to you.
We can take that one, but 1988 is actually next. Or no, I'm sorry.
Oh,
is that 1988 is next. It's out of order, but yeah. Okay. 1988 is next. Can we take 1988?
Yes, that's not what I had on my script, unfortunately. Sorry.
Okay. Sorry about that. So it's agenda item
That's
7
okay.
of 1980. We are out of order on that. I'm not sure why. We tried to group so the next 4 or 5 bills, we tried to group all of the AI. Usually we go in the order of bill number, so AB's first and then SB's second chronologically.
Right.
But we're still doing that to an extent, but we tried to pull all the AI bills into one place because there's several of them. And so we thought it would be, rather than bouncing around, talk about them all at once. So the first one up is AB 1988, companion chatbots, crisis interruption pauses. And so what this bill is proposing is safety protocols for companion chatbots by requiring operators to establish policies for detecting credible crisis expressions and issue warnings, and initiate a mandatory crisis interruption pause after 2 credible crisis expressions within 72 hours and directing users to the 988 Suicide and Crisis Lifeline. And I will note that this bill was amended recently a couple of days ago, so we're looking at the new version of this bill, amended April 14th, 2026. So existing law has already last year put some laws in place to start establishing some regulations and statutes around chatbots. Currently, based on law established last year, if a reasonable person interacting with a companion chatbot would be misled to believe they're interacting with a human, the operator must issue a clear, conspicuous notification that the chatbot is artificially generated and not human. It requires the operator of a chatbot to maintain a protocol for preventing production of suicidal ideation, suicide, or self-harm content to the user, and must provide a notification to the user that refers them to crisis providers, such as the suicide hotline or the crisis text line, if they expressed suicidal ideation, and they need to publish details of their particular protocol. Also, if the user is a minor, the operator must disclose that the user is interacting with AI and clearly and conspicuously provide a notice every 3 hours, reminding them to take a break. And on July 1, 2027, or beginning then, the operator must annually report to the Office of Suicide Prevention the number of times in the past year the operator has issued a crisis service provider referral notification and what their protocols are. So they're trying to put various laws in place related to that. This effort started last year and is continuing on. The law also currently provides that a person who's injured as a result of any of the violations of things I just discussed is subject to a civil action for injunctive relief, damages, and attorney's costs. So this bill attempts to take the existing law a step further. It requires an operator of companion chatbots to adopt and make a policy for identifying and responding to credible crisis expressions, including what their policy is in terms of terminating the interruption pause, suspending your counseling and account, notifying appropriate contacts or authorities. So they have to have a protocol in place. It requires them to implement a system for monitoring and detecting credible crisis expressions in a user conversation for every chatbot they make available in California. And so what the system has to do is all of the following. So for the first crisis expression, the chatbot must immediately warn the person that it has detected the crisis expression, and if it detects another one within 72 hours, that it is going to begin a crisis interruption pause. And during that pause, the conversation will be suspended until a human moderator has reviewed the expression. The warning needs to acknowledge the person's distress in non-judgmental language, encourage them to seek immediate human support, communicate that they may feel relief after a short conversation with a trained crisis counselor, and that reaching out may help them feel less alone. And then it needs to display the 988 Suicide and Crisis Lifeline information. So that's for the first expression. If a second expression is detected within 72 hours, then the system must commence the crisis interruption pause immediately with no further conversation. During the pause, the chat bot needs to acknowledge the person's distress in non-judgmental language, encourage them to seek immediate human support. They need to communicate that the pause is intended to interrupt rumination and reduce emotional intensity, and that many people feel relief after a short conversation with a trained crisis counselor, as well as display the 988 Suicide and Crisis Lifeline information. It also must inform the user at this time that the pause will continue until a human moderator has reviewed the chat and determined an appropriate course of action in accordance with the operator's policy. And it prohibits the chatbot operator from terminating the crisis interruption pause until a human has actually reviewed the expression in context and it determines the appropriate course of action. The chatbot operator is prohibited from describing a crisis interruption as a punishment, a violation, or an enforcement action, and it prohibits them from providing the user with any diagnosis, labeling, or risk level assessment. And then the chatbot operator must document all credible crisis expressions detected, and the duration and conditions of each one, and any action taken in response to that. And it provides that any violations of this is a civil action for injunctive relief, damages, and attorney's fees. So the author, in bringing this bill, they note that the chatbots are rapidly becoming a place where people turn to for emotional support, but that they can fail to appropriately handle serious mental health crises. So that is this bill. And Chris, back to you.
Any comments from our committee members? I think this is I think this is a good thing. I think we need to be really careful, especially with kids as they start using AI and using chatbots to to kind of go through their stuff. So I was happy to read this, that there'll be some regulation put on how those are going to be used. So I'm in favor. Are there any concerns that we have from our committee based on the language of the bill? John.
Kelly, you had your hand up. Do you want to go first? Sorry.
No, I was just going to say I absolutely 100% in support of this bill. I would suggest that we support.
Roseanne, a couple of questions because you have a set of definitions here. In anywhere in the bill, did they define human moderator?
Let me double check. Human moderator, yes. It means a natural person that is an employee or agent of an operator who reviews a credible crisis expression and is responsible for determining the subsequent course of action on behalf of the operator.
So there's no mention there that this human person has to have any type of crisis training or intervention skills.
No.
So I would like to consider that language could be really important. And we're not talking like full-on mental health professionals have to do this, but even crisis lifeline people go through a pretty intense training to be able to respond to the people who they're connecting with. So I think the human moderator is someone who has to have at least a very basic level of crisis intervention training in that definition.
Okay.
I had a second one. Do we know why they chose 72 hours?
No.
Okay. So if we're looking at crisis intervention, 72 hours seems like a really big window to leave open. I would suggest maybe consulting with some mental health professionals to look at a more appropriate like window on that. Even tightening it up as much within a 24-hour period.
Thank you, John. Any other comments from the committee? So then do we have a motion?
I'd move to support.
Do we have a second?
I'll second.
All right. Any thoughts on having an amendment to the language prior to supporting based on John's comments? Or do you like it the way that it is, Kelly?
If you'd like,
you know, I'm totally fine if supportive amended. I'm okay with that.
the question
Go
becomes,
ahead.
do you want to support it no matter what because you like the effort, or do you want to require the amendments in order to support it? I can try to reach out to the author's office with that feedback before the board meeting and see if they're amenable, if you'd like.
That would be helpful, yes.
Okay, so then we'll pause the motion and we'll reconsider in May when you've had a chance to talk to the office, to the author's office. Is that how I'm understanding it, Roseanne?
Or you can recommend support at this time if you feel like you want to do it, and then we can, or you can recommend support if amended. I don't, or you can be, yeah, it kind of depends on, do you want to support if the author's office says no, we're not going to make any other changes, which I doubt they will say, but if they do you still want to support the bill?
I do.
Yeah.
I'm not sure about board member Sovek.
Well, I'll jump in here too, though. I mean, even if we ask for things and we get them, great. But even if we don't, this is still better than the status quo. So I think I'd be inclined to support it no matter what. Is there a way for us to take an action today of support and sort of Roseanne, direct you to kind of look at some of these issues that have expressed and bring back, whatever.
Yeah, and I can explain that context at the board meeting. I'll say, preliminary, the view is to support, but we would like to have the moderator to have crisis training and intervention skills. And we asked them about looking into the 72-hour window, and I can let you know their responsiveness, and then the board can make its decision with that full context.
And remember, this is a recommendation to the board, so I mean, you can change it.
It can change. It's not set in stone.
Right. So then I'm hearing that Kelly's original motion will stand, with Wendy's second, with Roseanne going back to the author with the requests that we have, and then that recommendation can go to the board. Is that correct?
Yes.
John? Okay. It's correct.
So I
and
just
then
want
John.
to go ahead.
No. I wanted to clarify with Steve and Roseanne, and we did. So you're good.
Okay.
Go ahead, John.
So I can't take a clean support on this. And I want to give you an example of any time you call into any customer service line. And we often tend to get the least common denominator of person, if we finally get through to a person, to be responding to that call. And it's a tough industry, and most people who are in these types of response things are overworked and underpaid. And so we are saying, yes, go ahead with this bill as written, with no idea of who these human moderators need to be or the type of training they need, understanding we may end up once again with someone overworked and underpaid who has absolutely no training in how to respond to someone who's in a crisis situation. As a mental health provider who has done a lot of suicide training, has worked with suicidal clients in the past, there are really specific do's and don'ts to that process. And there are specific questions you need to be comfortable asking. And from those responses, certain decision trees that you need to follow. So by not having someone, the human moderator, having any inkling of any type of training in crisis response, I can't take a support bill or even recommend to the whole board that we support.
All right. Thank you, John. Any further comments before we go to the public?
No, but I have a question for John.
Yep.
John, is the correct term to ask them for is the person have training in crisis response and intervention? Is that the right wording?
I would suggest specifically because we're addressing specifically suicidality here. That is the intention of the bill, correct?
Yes.
Okay, then suicidal crisis response.
Suicidal crisis response. Okay, thank you.
Chris, you have any better language for that? I think that's what I want.
No, that is the language. That's exactly right. Suicidal crisis response is the correct terminology. And your points are well taken, John. 100%. All right. Do we have any comments from Shanti?
Hi, Shanti Ezrin with CAMT. No comments, just sharing that this is a watch bill for CAMT.
Thank you. Any comments from our online participants?
This is the moderator. We do see a raised hand. Ben, you're going to be seeing a request for to unmute yourself and make your comment, please.
Thank you. Good morning. Ben Caldwell, MFT. I don't have a specific request for the committee here. I would just point out that intent to harm self or others and desire to harm self or others, both of which are captured by the language of this bill, are very different things. Desire to harm self or others is quite common, can be fleeting, and most commonly is not indicative of a crisis. How many times have you had the thought or even said out loud that you'd like to smack someone for something dumb that they said? Some of you may have had that thought about me from time to time. As written, this bill is likely to capture a ton of situations that aren't actually crises, which would add a huge administrative burden in situations where that burden wouldn't actually protect user or public safety. It might make more sense to narrow the scope of this bill to just expressions of intent to harm, rather than expressions of desire to harm. But whether that's a concern of the board or this committee, I'm not sure. Thank you.
Thank you, Ben.
Thank you. We have Kathy Atkins. You're going to be seeing an unmute so yourself prompt on your screen. Please click on that and to make your comment. Kathy, if you are speaking, we cannot hear you. You still seem to be muted. Please click on the unmute yourself prompt to be able to speak.
Hi, this is Kathy Atkins from the California Association of Marriage and Family Therapists. Good morning. As Shanti noted, we're not taking a position at this time, but I appreciate Roseanne putting these bills together, because that is what we're doing at CAMF 2, is trying to assess all these bills, including the one that CAMF is co-sponsoring that we discuss later, to look at them in totality, dealing with healthcare, mental health specifically, and AI. What we're seeing is a lot of well-intentioned, passionate, necessary legislative efforts to help protect especially vulnerable populations, while accepting that AI is here and how to utilize it in a productive, healthy manner. I just make this statement as CAMP is not sure on some of these bills what direction will lead, but we appreciate all the efforts of the various authors and sponsors, recognizing also many of these bills, including somewhat ours, are imperfect because we're dealing with a technology that we're all still learning about. So I just appreciate listening to the conversation and the questions and the points, because it actually helps us improve our own legislation as well as assess these other ones. So just thank you to everybody.
Thank you, Kathy.
Thank you. I see no other raised hands. I return the floor back to you, Chair.
Thank you, moderator. Christina, would you take the vote?
Before I take the vote, I'd like to ask Kelly to please repeat the motion on the floor.
Motion is to support the bill.
Thank you. Chris Jones?
Yes.
Kelly Ronasinga?
Yes.
John Sovek?
No.
Wendy Strack?
Yes.
Motion carries.
All right. Thank you. It is 11:30. Did we want to take a break and come back and get through a few more of these before we stop for lunch, or do we want to call this lunch?
Yeah. 15.
Which one?
Want to do the 15?
When you do a 15 and then like in an hour, do it lunch. Oh,
Okay.
let's do that.
So if we do a 45-minute lunch, then we can not have to do a 15 and then take an hour or another 45 minutes later. So maybe 45 minutes now, if that's all right with everyone.
That works for me. I got the thumbs up from Wendy, so there we go.
And then we can just
all right
on through. Okay.
Yeah, so we'll see everybody back at 12:15. Thank you.
Thank you.
Thank you.
So cool.
Eva, we're ready to go?
We are all here.
Excellent. Welcome back. I hope everybody had a nice lunch. We are moving on to agenda item number 8, which is discussion and possible action to make recommendations regarding Assembly Bill 1979, BONTA, Healthcare Services Artificial Intelligence. Roseanne, would you please provide us with an overview?
Yes, thanks, Chris. So AB 1979 prohibits health facilities and medical officers from using AI tools for any tasks that replace the professional judgment of a licensed healthcare professional in carrying out their duties. And it also bans the use of AI to direct, guide, or instruct unlicensed personnel in performing any functions that require a professional license. So in terms of existing relevant law, we have the Confidentiality of Medical Information Act that specifies business that offers software or hardware to consumers designed to maintain medical information to make it available to a health provider for diagnosing or treatment a medical condition is subject to the requirements of the Confidentiality of Information Act. And a business that does this must maintain the same confidentiality standards as a healthcare provider does. And then we also have a law that prohibits or provides a health facility, clinic, or doctor's office that uses generative AI to generate written or verbal patient communications regarding patient clinical information must use a disclaimer that the communication was generated by AI. In terms of this specific bill, it's making an amendment to the Confidentiality of Medical Information Act, basically expanding upon the statement that a business that offers software or hardware to consumers that's designed to manage the individual's information. It clarifies that managing the individual's information also includes the ability for somebody to query their medical history, summarize doctor's notes, or organize lab results. So a program, a hardware or software program that does those tasks, the bill clarifies that is also subject to the Confidentiality of Medical Information Act. And then it has the provision I discussed about prohibiting a facility physician's officer group practice from deploying an AI to replace the use of professional judgment by a licensed healthcare professional carrying out their duties, or direct, guide, or supervise unlicensed personnel in performing functions that require a professional license. The bill clarifies that the above prohibitions that I just mentioned do not prohibit using AI for documentation and communication that does not require professional judgment, such as automated messages to inform a patient that their health record has been updated. And then it specifies that the penalties that apply for violations of the above include that a licensing board may pursue an injunction or restraining order for unlicensed practice. And so the author in running this, talks about how AI is rapidly expanding into the healthcare system and that there's a lot of promise to the technology, but there's also a lot of risks to patient safety. And they're trying to ensure that these entities that are using AI are abiding by the law. And then we have opposition to this bill at the same time, arguing that the bill is too broad, prohibiting AI assistance in activities like patient assessment and clinical documentation under supervision. And they argue that in many cases, these tools are already in use and overregulating them would discourage their use, eliminate their utility, and undermine efficiency gains. So I think that there's going to be a long back and forth over the summer about this bill and how best to sort of balance these and getting that worked out. One thing that I noted about the bill is that the bill prohibits health care practices from using AI tools to replace the use of what it calls professional judgment by a licensed healthcare professional, but it doesn't define what professional judgment is. That's a broad term, and it might be subject to different interpretations by different people. And so not having an explicit definition could limit the use of AI in legitimate instances where it might be helpful if practitioners are unclear about whether or not use involves professional judgment, and then therefore they're hesitant to using it. The other thing I did with this bill is kind of a comparison and contrast with SB 903, which we're going to talk about later today. This bill casts a very broad net to regulate the use of AI in the practice of all healing arts professions, while SB 903 is also attempting to regulate AI, but only in a much narrower realm of psychotherapy services. So my question is, could they conflict? For example, AB 1979 prohibits the use of professional judgment of a licensed healthcare professional. SB 903 allows AI in some instances, such as what it calls administrative or supplemental support. And so there's a potential that those could overlap. It's kind of unclear. So that should be discussed and considered. So in this case, I'm just going to open it up for discussion and see what the members and the public think about this.
Do you have comments? Kelly?
That professional judgment term is kind of key here, isn't it? I mean, if it's not
I
defined
think so,
inside
yeah.
the statute, it's just left to the courts. And that's never a good idea, you know? So, I'm kind of curious to see how this shapes out in the legislature.
I would agree with Board Member Ranasinga because, yeah, that seems at the whole heart of all of it. And to proceed down this path without a clear definition of what they're actually regulating is dicey.
Same thought. John, do you have any comments?
It does feel like 803 is more specific to our board and the people that we serve. So it's kind of like I wouldn't kind of think that our weight is more about 903 and helping to shape that a little bit more effectively.
Do we have enough information to make a motion, or did the committee want to hear from the public first?
I'm open to hearing from the public.
Okay. Shanti?
Well, hi, Shanti Ezrin with CAMT. Was actually just going to share that this is a watch for us. We can provide more information on the next agenda item when SB 903 comes up. And I know Anne from CAMT is also participating online. She can answer some of the more technical questions, whether it's in the next agenda item or if there's something specific that you'd like us to address here.
Okay, thank you. Do we have any comments from our online participants?
Hi, this is the moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your screens. And if you are a call-in public member, you can press *3 to raise your hand. I do see a raised hand. Ben, you're going to be receiving an unmute request prompt. Please click on that to make your comment.
Thank you, Ben Caldwell, MFT. I have no doubt that this bill is well intended, but I do share the concern expressed by opponents that the bill is too broad in its present form. It would appear to prohibit or over-regulate systems that are already in place and seem to be unproblematic. Just as one example, there's an AI platform called Listen, Lyssn. I don't have any involvement with them, but to my understanding, that's already in fairly common use in mental health supervision. Not as a replacement for a supervisor, but as an opportunity for additional training and developmental exercises, that kind of thing. Listen also gathers data from supervisee sessions, and this bill would appear to mandate that if a system like that makes any supervision-ish summaries or recommendations, then it would be fully prohibited from use. So I'm not particularly pro or anti-AI, but that kind of prohibition does not make sense to me. So I respectfully request that the committee either hold off on recommending any position to the board, but maybe continue to work with the author and sponsor to address some of the concerns that are expressed here, particularly around that very fuzzy definition of what exactly is professional judgment, because as committee members have said, that's kind of the whole thing. Thank you.
Thank you, Ben.
There are no other comments. I return the floor back to you, Chair.
Thank you, moderator. I tend to have similar feelings that Ben does, that maybe we should hold off and work with the author's office more. Do the committee members have a different opinion? And is there any, no? So we don't want to make a motion then? We just want to kind of wait and see. All right, Roseanne, does that give you enough direction? The professional conduct is the kind of the sticking point for us?
Yes, that makes sense. I will reach out.
Okay, perfect. Thank you so much. Appreciate it. Make sure Steve gives you a vacation after this meeting. Well deserved.
Definitely deserves
I have
it.
Good. Okay. Next on the agenda is discussion and possible action to make recommendations regarding Senate Bill 903, Padilla, mental health professionals, artificial intelligence. Roseanne, back to you.
Yes, so this is the one that I just mentioned that really dives down into the use of artificial intelligence in the use in using it in the mental health professionals, and it's sponsored by the California Psychological Association, CAMPT, and the California Behavioral Health Association. So basically, just to broad summarize what this bill does, it does a couple of different things. It prohibits an individual, corporation, or entity from providing, advertising, or offering psychotherapy services, including via AI, unless they're provided by a licensed professional. It allows licensed professionals offering therapy to use AI for administrative or supplementary support, which it defines. It prohibits any psychotherapeutic communications or psychotherapy sessions from being recorded or transcribed unless specific consent requirements are met. And it prohibits anyone from using AI to make independent therapeutic decisions, generate therapeutic recommendations or diagnoses, detect emotions or mental states, or assess symptom urgency. So to kind of give some background under current law, and these two things that I'm going to mention come up later because the definitions or provisions are referenced in the bill. There is a law in Evidence Code Section 1010 that defines a psychotherapist. It includes our LMFT, LCSW, and LPCC licensees. It does not include LEPs. It includes our 3 types of associate MFTs, social workers, and professional clinical counselors. And it includes MFT trainees and PCC trainees, but not social work interns in the definition. Also in existing law, there is a provision that prohibits healthcare providers and entities from releasing medical information about a person's outpatient psychotherapy treatment unless the requester provides a detailed written request, gives notice to clients, and agrees to strict limits. But it does outline certain exceptions, including disclosure to law enforcement in specified situations. Existing law also provides that unlicensed practice in violation of any of DCA's practice acts is an infraction punishable by a fine. And then we have some new provisions that were run last year in AB 489 that prohibit they provide certain prohibitions on the use of generative or AI in the healthcare professions regulated by DCA. It makes violating requirements in law that prohibit the use of specific terms, letters, or phrases to imply having a license or certificate or to practice a healthcare profession without actually having one is a violation enforceable against a person or entity that develops or deploys an AI or Gen AI system. And it prohibits using any term, letter, or phrase in advertising or functionality of an AI system that implies the care, advice, reports, or assessment offered is by a natural licensed person. And violations are subject to the jurisdiction of the applicable licensing board, which could be an injunction, restraining order, or other authorized remedy. So that's existing law. And so now I'm going to dive into exactly what this bill does. it establishes what's called the Wellness and Oversight for Psychological Resources Act. And it's seeking to safeguard individuals seeking therapy by ensuring those services are delivered by licensed professionals and not unlicensed providers like an AI system. The definition that the bill uses is the definition of psychotherapist in Evidence Code Section 1010, which includes all board license types except for LEPs and social work interns, which I'll come back to. The bill prohibits an individual, corporation, or entity from using AI to record or transcribe psychotherapeutic communications or sessions, triage, or screen unless the patient and their representative is informed verbally or in writing that AI will be used and the purpose of the AI, and that the patient or their representative consents. It prohibits an individual, corporation, or entity from providing, advertising, or offering psychotherapy services, including through AI, unless it's conducted by a licensed professional, and it permits an individual, corporation, or entity providing psychotherapeutic services or conducting triage to use AI only to the extent it meets this act, and it prohibits it from using AI to make independent therapeutic decisions, directly interact with clients, unless consistent with unless the tool is consistent with the U.S. Food and Drug Administration's guidance for low-risk general wellness products or clinical support software, which is actually, they have a memo on it, what that is that I linked to. And it has to be also compliant with HIPAA. The tool cannot generate therapeutic recommendations, assessment results, diagnose or treat, detect emotional or mental states, or assess health concerns or symptoms for urgency, clinical nature, or appropriate level of service. It provides that if a licensee is using AI in connection with psychotherapy, it has the use has not been selected or provided or mandated by the employer, that the licensee is responsible for ensuring that AI is deployed in compliance with this act. But then if it also provides that if a licensee is using AI that is required or authorized by their employer or contracting entity, then it's the employer or contracting entity that's responsible for the ensuring the AI is deployed in compliance with the act. So there's a little bit of a designation of responsibility there. But the licensee still must use it in a clinically appropriate manner. It prohibits a company or entity from sharing, selling, or storing or training their AI models on any data obtained from psychotherapy, and makes violations of this act subject to the jurisdiction of the appropriate licensing board or enforcement agency. And it exempts religious counseling, peer support, AI use for training or simulations, and publicly available self-help materials and educational resources that don't purport to offer psychotherapy from the provisions of the act. The bill also contains numerous definitions. It is a specific definition of religious counseling and peer support. It defines administrative support, which licensees may use it for administrative support as tasks to assist the licensee in the delivery of psychotherapy that don't involve psychotherapeutic communication. Examples would be managing appointment schedules, billing and insurance, drafting general communications related to therapy logistics that don't include advice. And then it also defines supplementary support, which therapists are also permitted to use AI for. These are tasks that assist a licensee in delivering psychotherapy, but they don't involve psychotherapeutic communications. Examples would be preparing and maintaining client records, including progress notes, analyzing anonymous data to track client progress or trends, identifying external resources or referrals for use by the client, assisting with documentation or workflow management. And then it has a very specific definition of psychotherapeutic communication, basically direct interactions with clients, guidance, therapy strategies or interventions, offering emotional support, reassurance, or empathy, collaborating with clients on therapeutic goals, and behavioral feedback to address mental health conditions. So that's what the bill is doing. In terms of analysis and background information, the author is, of course, seeking to protect consumers seeking therapy from the increasing use of unregulated AI systems. It builds on last year's AB 489 that put basically, purporting to be a therapist, AI systems saying that they're a therapist or that they practice marriage and family therapy. It prohibited that, things like that. This bill is, well, when it was originally introduced, it was modeled on legislation from the state of Illinois. It's kind of moved away from the recent amendments, kind of moved away from that. But Illinois was basically the first state to adopt legislation on this. Several other states either have pending legislation or have since adopted it. I've included the examples of Illinois, Pennsylvania, Florida, and Nevada. Nevada's has also been signed into law. I've included those in the appendix if you're curious what they look like. I've also included some resources from the American Association of State Counseling Boards. They produced a document that's intended to support state licensing boards in their public protection duty as AI tools, as it relates to AI tools. So that's some background information. In terms of complaints to the board, we have been noticing that within the past year, we've had a few complaints, new types of complaints related to the use of AI therapy. For example, a complaint about a therapist's use of AI to write therapy notes where the complainant had opted not to consent to the use of that AI system. A complaint about a therapist accidentally pasting a client's personal identifying information into AI. And a complaint about a therapist using AI to guide client interactions during a session. So in terms of that, we expect this bill, in terms of a fiscal impact, the bill could possibly increase complaints directly related to licensees by about 5%. That would work out to about 150 complaints per year. So we are asking for 1 permanent half-time staff analyst 2 to assist with the workload. On the other side of this bill, it also provides some general authority to take actions against companies. So in terms of the fiscal for that, we don't really know at this time. It's kind of difficult to estimate that, as we don't know how many complaints and what would be involved in that. So that's kind of ambiguous at this point. Diving into some really technical considerations that I've brought forth in the analysis and analyzing this bill. I'm just going to go through these each one. In terms of using evidence code 1010 to define licensed professionals, that's a step forward in versus how the licensed professionals were previously defined or not defined in the beginning first version of this bill. So it's a step forward. However, staff does have a concern that LEPs and social work interns are not included in that definition in evidence code 1010. It's likely the intent of the bill that those professional categories also be included. In terms of the definition in the bill of religious counseling, it defines religious counseling. There's a very specific definition. Separately, and then it exempts religious counselors from the provisions of the bill. In AB 1598, the board is pursuing its own definition of what we're calling faith-based counseling in order to better define when such counseling is exempt from the board's Practice Act. I've included that proposed language. Because this act applies to numerous licensing boards and not just this board, it might be reasonable for the definition to vary. However, the board should discuss if the differing definitions cause any clarity, concerns, or affects the board's practice exemption, because we are actually defining faith-based counseling and then exempting them from the Practice Act. So we're a little bit concerned about that undermining it. In terms of the definition of supplementary support, part of the definition states that supplementary support includes analyzing anonymized data to track client progress or identify trends subject to review by a licensed professional. It might be just clearer to require it to be reviewed by a licensed professional rather than subject to a review. Staff also questions whether all of the 4 tasks listed under supplemental support should be required to be reviewed by the licensed professional instead of just the one item. I don't know. I'll leave that up to the clinicians in the audience. So one of the things that I had a really hard time with understanding and analyzing this bill was the definition of use of artificial intelligence. That definition includes the permission that a therapist may use administrative support and supplementary support with permission to use for a therapist to use administrative support and supplementary support only occurs in that definition. It doesn't occur in the body of the text. In the body of the text that actually says what is permitted and not, it only uses the term use of artificial intelligence. So you have to really go back to the definition and remember that use of artificial intelligence includes supplementary and administrative support when the bill is talking about it, what it permits and not, which I think it kind of was circular and sort of hard to understand. And I think that if it was hard for me to understand, it might be hard for somebody to understand that's trying to comply with the law. So I just think it's too subtle, and it might be clear for the bill to explicitly state the permitted uses and non-permitted uses of AI for licensed professionals in one section, and then separately state the permitted and non-permitted uses of AI for non-licensed individuals, corporations, or entities in another section, because it seemed like it was really kind of hard to parse out like what was allowed and not allowed for who there. Also kind of related to that, in terms of consent required for recording or transcribing, the bill prohibits the quote unquote use of artificial intelligence, which is a defined term, to record or transcribe psychotherapeutic communication sessions or triage unless the patient is informed about the use of AI and gives consent. That's the only place in the bill that discusses consent. The bill does not clearly address whether consent is also required if a licensee is using AI for administrative or supplemental support, which, as I mentioned, that's rolled up in that use of AI term. But this case only appears to be talking about recording, so it's confusing to me if administrative and supplemental support are meant to be rolled up into that. So that was kind of the main piece that I was having trouble with when I was trying to go through the language. Additionally, a question that came up in the discussion of the fiscal for this bill is kind of the jurisdictional ambiguity. The bill states that violations are subject to the jurisdiction of the appropriate licensing board, and that's fine in a case where something's clearly, in violation because it's claiming to be a marriage and family therapist or a psychologist or something like that. But it becomes unclear where the violator is not holding themselves out to be any particular type of licensed psychotherapist. It's just sort of doing psychotherapy. The bill defines licensed professional, and that encompasses multiple professions regulated by different boards, including medical board, behavioral sciences, psychology board, registered nursing board. So it kind of begs the question, who would take the lead in those investigations and who would pay for those investigations? If there was a violation, and how would that be funded? So the bill may benefit from specifying how jurisdiction is determined if the license type is not apparent. I think I'm going to open it up for discussion at this point. I feel like I've said a lot. So
There's a lot to say. Yes, there's definitely a lot of components to this bill. I appreciate that you're going to reach out and ask about LEPs. I'm always confused as to why we get left off the playground. So we'll start there. Do we have any comments from our committee members?
I would just say it seems to me like this is something that we could consider like maybe a support if amended position on, and address the lengthy list of questions that Roseanne has raised. I don't have anything to add to that list, but certainly I think there's a lot of clarifications that are needed. But perhaps the there's good intentions there and it's worth working with them on. That would be my initial reaction.
I would agree with Board Member Strack. I think there's enough here that we could support if amended, but we have enough concerns, particularly how LEPs would fit into 903. I think that's very important. Otherwise, they're kind of off outside in this orbit of stuff that is also regulated. So I would agree with Board Member Strack as supportive amended.
John?
Hey, Roseanne, I have a quick question for you. And this has to do with y'all have trained me about the subtleties of language over time. Um, on on page 9.3, under your this bill uh, information, number 2 says that we're defining licensed professional using evidence code 1010. Are we going to run into any weird variables later on with the word licensed professional, considering 1010 uses unlicensed people? Is that going to circle around and cause some trouble in the future?
That's a great question. No, I don't think so, because this is in the Business and Professions Code, and section, I think it's 25.4 or 5 defines whenever the Business and Professions Code uses the term licensed professional, that also means registered.
And Roseanne, I appreciate that you just pulled that out of the back of your brain. Thank you for that.
You're welcome.
Also on this bill in item 3, it says it's about the consent forming, and it says either verbally or in writing. I would like to suggest when we talk to the authors that we take the verbally out of it. Oftentimes in therapeutic situations, when we just say, hey, do you agree to this or something like that, there might be a sense of coercion or like a client wanting to be a good client and agreeing versus an actual written consent, which says, oh, you need to pause, you need to look at this and sign this. I think it just provides a safer level of consent than just a quote unquote verbal consent that might be noted in the therapist notes.
Okay, I'll add that to the list. Thank you.
All right, then do we have a motion from our committee?
I'll make the motion to support if amended. Roseanne, I don't think you need us to outline what those are. I think you.
No, I think it would be a support if amended to include the list under technical considerations in the memo, plus John's additional request for the consent to take out the verbal consent portion.
Yep. Sounds
John
great.
Sovak, I'll second.
Perfect. Thank you. Any further discussion from our committee members? All right, Shanti.
Thanks so much, Shanti Ezrin with CAMT. I'll just begin. Roseanne, thank you for the very deep review of the bill and for highlighting the technical considerations that's listed in the material. Just to repeat some of what you've already covered, CAMT is co-sponsoring this bill with the California Psychological Association, California Behavioral Health Association, as well as the National Union of Healthcare Workers. Highlighting again at a high level what you've covered, the bill primarily does 2 things. 1, it works to promote safe and ethical use of AI for providers, and 2, work to protect consumer and protect human-centered therapy for clients. Really at the core, this bill protects patients from unregulated AI therapy, safeguards privacy, and maintains clinical responsibility and accountability with human providers. Really greatly appreciate the committee and board support on the bill. I know Kathy and Ann, who are also with CAMT, are online. They can speak a little bit more to the technicalities of the bill and be available to answer if there are additional questions that haven't already been addressed. Thank you.
Thank you, Shanti. Comments from our online participants.
Hi, this is the moderator. We do have a couple of comments. Dr. Lisa, you're first. I'm going to send you the unmute request and you can make a comment by clicking.
Bunch. First, I'm really, really grateful that this is happening. Even when this goes into place, it's almost immediately going to be outdated, at least a little bit, because the field is moving so fast. Also, therapists, this is so random, I apologize, this list I'm giving you. Therapists are not technical. This is going to freak them out. So I hope somewhere in your budgeting, you're including some budget category for inquiries from the licensees when they panic, when they hear about this. And then related to that is this is actually requiring the tech companies to comply. And I have no knowledge whether the BBS or anybody has jurisdiction over those companies to force them to comply. So that's a huge question mark for me. I'm going to cover a few items I think are super important. One, do not surrender the rights for the client to care if they do not consent to the use of AI. Currently, today, Kaiser contracts with third-party providers such as Growth Therapy. Kaiser requires Growth Therapy's online telehealth environment to be used, or the client cannot seek care from that particular provider. So already there are problems potentially where some of these insurance providers are requiring the use of AI. So I really want to emphasize the need for the client's rights to be protected here. Another aspect, prohibiting the training models to scrape or to use the psychotherapy data to train these AIs. Let's please make sure this applies to all technology, including something like Zoom or something that is not currently within, they don't claim to be providing AI tools or providing tools in the therapy space. Let's please make sure that we can cover all access when telehealth and psychotherapeutic data is coming through in all of these places. I'm running out of time. There's a caution on the administrative support. I think I'm repeating some of this stuff. Roseanne, you did an amazing job. This is such an absolute contribution to the field, just this document. I have other things, but I'll hold them.
Thank you.
Next up is Kathy Atkins. You're going to be seeing an unmute request on your screen. You can click on that to make your comment. Kathy, if you are speaking, we are still unable to hear you.
Good afternoon, everyone. This is Kathy Atkins from CAMFT. I concur with various people that, Roseanne, thank you for outlining that. You did an excellent job, so thank you. The goal of this bill, or CAMF's purpose, is really to create good law. And I think to do that, especially with something like this, it's such a behemoth. CAMFT, as well as other co-sponsors, need not just the positive feedback, but the critical feedback. And so it's absolutely welcome. And I can tell you, Shanti, Ann, and I are furiously taking notes. So we actually appreciate the questions, the comments, all of it. So thank you. Roseanne and staff have provided already some great amends and comments and questions. And I know the co-sponsors continue to look at those and assess them. And again, we're still taking notes on what everyone's saying. Anyways, I just wanted to say we look forward to continue to hear from you all. And we have Ann Tran, like I said, from CAMFT. If there was technical questions, she's a little bit more apt at that. But again, thank you.
Thank you, Kathy.
Thank you. Next, we have Ben. Ben, you're going to be seeing an unmute request on your screen. Please click on that to make your comment.
Thank you. Good afternoon, Ben Caldwell, MFT. I really just want to reiterate a couple of points here. First of all, Roseanne, thank you for your great work on this. It's a highly technical bill and review, and just outstanding work. I also really want to thank the sponsors for their work on this bill. Just as a licensee and an educator, I really appreciate all that CAMFT in particular has done and is continuing to do related to the deployment of AI in mental health care. I know this bill has a long way to go, and I appreciate Kathy's willingness, CAMFT's willingness to take in all the feedback along the way to make sure that it does result in really good law. I don't have anything else to add. Just wanted to express gratitude. Thank you.
Thank you, Ben.
Next up, we have Bindu. You're going to be seeing an unmute request on your screen. Please click on that to make your comment. Bindu, if
Oh, good afternoon. Hopefully you can hear me, chair members. My name is Bindu Mukamla, policy manager representing the National Association of Social Workers, California chapter. Again, huge shout out to Roseanne and everyone here doing an in-depth review of all the bills, not just SB 903. So we appreciate it. And then a lot of the bills on today's agenda are on our watch list. And so going back to SB 903, we see that AI tools are continuing to expand in mental health settings, and it's critical that innovation will not come at the expense of client safety, informed consent, and professional accountability. And we also know that AI tools lack the clinical judgment, ethical responsibility, and also human understanding required for safe mental health treatment. So we believe that clients deserve to know when AI is being used and have confidence that licensed professionals remain responsible for their care. So we believe that SB 903 helps establish those guardrails by ensuring therapy services remain under the oversight of licensed mental and behavioral health professionals, and also will prohibit AI from making clinical decisions, and also requires disclosure of consent when AI is used to record or transcribe sessions. And so for these reasons, NASW California strongly supports SB 903, and just wanted to emphasize the great work that the sponsors have been doing on this bill. Thank you.
Thank you.
I see no other raised hands. I return the floor back to you, Chair.
Thank you. Okay. Christina, would you take the vote?
Chris Jones,
Yes.
Kelly Ranasinga,
Yes.
John Sovek,
Yes.
Wendy Strack.
Yes.
Motion carries.
All right. Thank you. Next on the agenda is the discussion and possible action to make recommendations regarding Assembly Bill 2575 Ortega, Healthcare Services Artificial Intelligence. Roseanne.
Yes, so this bill tackles the AI issues with healthcare professions at a different angle. So this bill is trying to set guardrails for healthcare workers using AI and clinical decision support systems by doing a few different things. It prevents developers from avoiding liability by claiming that a healthcare worker's failure to override an output absolves them from liability. It requires that each healthcare provider or person using an AI or clinical decision system provided by their employer receives a written notice that has some pretty extensive information that I'll go over in a minute, explaining how the tool works, its limits, and its data. And then it protects the healthcare worker's professional judgment by prohibiting an employer from restricting it with artificial intelligence and banning retaliation for either overriding it or following its outputs. So under existing law, there's a couple of relevant things here. Existing law provides that a defendant who developed, modified, or used an AI may not assert or use in a defense in an action against them alleging harm that the AI autonomously caused harm to the plaintiff. And then it requires that any health facility, clinic, or office or group practice that uses AI to generate written or verbal patient communications regarding patient clinical information must include a disclaimer that the communication was generated by AI. So this particular bill is trying to do the things that I outlined a minute ago. In terms of what needs to be disclosed to the healthcare provider, so basically if a health facility or a group office or practice is using an AI or a clinical support system for patient care, they need to provide a written notice to the person that's going to be using it, including licensed health professionals, about a lot of different things, about background information about that system, about anything from details about the developer, funding source, and output, its intended use and cautioned out of scope use, its limits, development details, including the training set, demographic representativeness, and known biases. And notice that a worker providing direct patient care is permitted to override the output if in their professional judgment and their scope of practice, that override is necessary for the patient or necessary to comply with the law. And that disclosure needs to be provided at certain times. Either it needs to be provided upon hire, if they're going to likely use it, at least 90 days before a new covered tool is deployed, 90 days before a material change in the tool, and then they also have to provide an annual updated inventory of tools currently in use. The disclosure needs to be in plain language and linked to the health record of patients whose care may be affected or whose health information may be used as an input. and it needs to be provided within ample time for the healthcare professional licensee to review and make decisions on whether and how to use the tool. It also provides that a employer cannot use or deploy these technologies to replace or limit a worker's use of professional judgment, and they can't retaliate or discriminate against a worker if they override it, because in their judgment, in their scope of practice, an override is appropriate. And they can't discriminate with the worker's compliance with the output of the technology if it was provided or approved by their employer for patient care. Anybody who is subject to retaliation has the right to file a complaint with the labor commissioner. And so the intent of this bill is the author is trying to protect healthcare workers who are being required to use these AI tools by their employers. And there has been questions about what, there were instances where they were forced to set aside their own professional judgment based on the recommendations. So this is trying to protect against that and provide some worker rights. So it's sponsored by the California Nurses Association and the California Labor Federation. And you can see the list of support and opposition in the bill. And with that, Chris, I'm going to turn it back over to you.
Okay. Comments from our committee members.
I don't have a really substantive comment, but from a legislative standpoint, you're going to have AI like spread across like 5 different codes. Like you want a bit in like the labor code and then the business and professions code, and then you're going to the evidence code. I mean, it's going to be a big mess. You're going to have to like have 5 books in front of you to like understand where you're going when you're looking at AI problems. That's it.
That is definitely in reading this, I mirror your feeling, but it feels like a lot of these could be possibly consolidated. But I think they're trying to work all that out. And I expect these bills that we are going to be seeing them evolve as the summer moves on.
Any other comments? No? Okay. Do we have a motion?
I move to take no action on this one.
I don't know that we need a motion for that, Kelly, but I appreciate it.
Yeah, you don't need a motion for that.
No, I just should shut up.
No, you're fine. You're fine. You're fine. You're fine. There's a lot of technical things that are happening here today. So I get it. All right. So okay, then let's open up comments from Shanti. Start with you.
Thank you again, Shanti Ezrin Campt. This is a watch for Campt and no additional comments at the time.
All right. How about comments from our online participants?
This is the moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your WebEx screen. And if you are a call-in public member, you can press *3 to raise your hand. I do see a comment from Ben. Ben, you're gonna be seeing an unmute request and you can make a comment.
Thank you, Ben Caldwell, MFT. There's an emerging theme in AI regulation that practitioners should not be able to pawn off accountability for their actions by blaming AI systems when something goes wrong. The recently updated CAMF Code of Ethics, for example, makes clear that clinicians remain fully accountable for their clinical decisions, even when those decisions are based on AI drafts or recommendations. In that light, the anti-retaliation piece in this bill is a concern. It would protect employees from employer retaliation for following AI guidance. But by doing that, what this would do in practice is create the very thing that our professional ethics and other regulations are trying to avoid, which is an opportunity for an AI user, after following AI guidance that a reasonable professional should know was wrong or even dangerous, to avoid responsibility by saying essentially, it's not my fault, the AI did it. In that situation, under this bill, the employer can't avoid responsibility, but the employee can. So for that reason, I'd respectfully request that the committee consider maybe taking an opposed unless amended position on this bill, with the amendment being to clean up that anti-retaliation piece in a way that employers can discipline employees for following AI guidance when that guidance should reasonably be overruled by appropriate professional judgment. Thank you.
Thank you, Ben.
I see no other comments. I return the floor back to you, Chair.
All right. Any further comments from our committee?
I guess I just have a question maybe for Roseanne about the concern that Ben just raised, and is that something that others are weighing in on as well? I mean, I saw AFSCME is engaged in the bill, so I assume the anti-retaliation piece probably is for them, but anyway, just wondering what our role in that particular component should be.
That's a good question. Give me just a second and I'll look up exactly what the opposition, if there's a current analysis, I'll look up what the opposition said. So they're basically saying AI goes through an extensive review that includes healthcare workers who are using them. No AI system is activated for use by medical professionals without a thorough assessment and ongoing monitoring. So it's basically saying that judgment is not excluded anytime. So I'm not really seeing that argument, although it's early on. Definitely Ben raises a valid and interesting point. I don't really have a recommendation one way or another on that. We can raise it if you want. I can provide that information to the author's office and see what they have to say.
Yeah,
I think that would.
Sorry, Chris. I guess my question.
No, go ahead.
That's our battle to fight. I mean, I think it's a valid concern. It's just whether it's within the board's purview to weigh in on that particular piece, or whether that's an employer-employee. Well, we weigh in on a lot of employer-employee relationships, but maybe the other licensed members of the committee have a better thought on that than I do.
No, I think having Roseanne reach out to the author is a great idea, and then we can come back to the table with it in May.
And yeah, I can just pose the question, that this concern was raised, and do they have a response? And we'll see if they respond.
Okay, wonderful. Thank you, Roseanne. Moving along, we are not doing item 11. So moving on to agenda item 12, discussion and possible action to make recommendations regarding Assembly Bill 2011 HART, non-quantitative treatment limitation. Roseanne.
Yes, this bill seeks to strengthen California's mental health parity law by codifying the 2024 Federal Mental Health Parity and Addiction Equity Act rules into California law. This is in response to the Trump administration stating it will not enforce the 2024 rules pending litigation surrounding them. So in existing law, the existing law says a couple of things about mental health parity. First, California law requires every health service plan or disability coverage policy that provides hospital, medical, or surgical coverage to also provide coverage for the medically necessary treatment of mental health and substance use disorders under the same terms and conditions applied to other medical conditions. So that's California law. And then there's also a federal law, the Paul Wellstone and Pete DeMassini Mental Health Parity and Addiction Equity Act 2008. That is a federal law that requires health plans offering mental health or substance use disorder benefits to ensure that the financial requirements like copays and the treatment limitations like visit limits are no more restrictive than those applied to medical and surgical benefits. That applies to group health employer plans over 50 employees. So this bill is seeking, the author is running this bill because they note that enforcement of the law has been inconsistent. Regulators have faced challenges with something called non-quantitative treatment limitations, which I'll discuss what that is in a minute, but basically that's things like prior authorization, medical necessity standards, network adequacy, all the really like technical details. There's ongoing challenges with them being equal between mental health services for insurance purposes and physical illnesses. And that lack of clarity and sort of muddiness of the water there has made it more difficult for patients to obtain mental health services despite the existing laws. So in response to that, in 2024, the Biden administration issued a new federal rule clarifying requirements for plans and insurers to collect data and conduct comparative analysis to measure the impact of non-qualitative treatment limits. And plans and insurers are required to take action if necessary to create parity for these limits between mental health and traditional medical coverage. So I'm going to go into what this bill does. It basically mirrors the federal regulations and is codifying them in California law in case they don't get implemented. With some exceptions, it's not a verbatim transfer of federal law because the author's office, when I talked to them about it, they looked at what exactly what federal rules that were in there were not codified. There were some instances where California law is stronger than federal law. So in those cases where the provisions might weaken the statute, those particular ones were not included, but everything else pretty much was. So what the bill does in terms of codifying the federal regulations is really the focus is on what is a non-quantitative treatment limitation. It's pretty technical, but it's things like medical management standards like prior authorization that limit or exclude benefits, prescription drug formulary design, network tiers with preferred providers, step therapy protocols, things that are required in order to have treatment approved, basically. So the gist of it is it prohibits a health insurance plan from relying on discriminatory factors or evidentiary standards to design a non-qualitative treatment limitation for mental health or substance use. And it's discriminatory if the evidence or standards for the factor are biased or non-objective in a manner that discriminates against mental health, substance use disorder benefits compared to medical surgical benefits in a way that disfavors access. So it's basically like making the mental health non-qualitative treatment limitations be more strict or severe than those for the medical surgical, if that, hopefully that makes sense. And so to make sure that the mental health non-qualitative treatment limitations are not more restrictive than those for medical surgery, the health plan or insurer that's implementing it must collect and evaluate relevant data and assess the impact on relevant outcomes for mental health and substance use benefits and medical surgical benefits, including material access differences, and consider that as part of their evaluation. And a healthcare plan that imposes the non-quantitative treatment limitations on mental health and substance use disorder benefits to perform and document comparative analysis of design and application for each non-qualitative treatment limitation applicable to mental health and substance use disorders containing specific information. And then it requires that analysis to be made available to the Department of Managed Healthcare and the Department of Insurance, who regulate the insurers, annually and upon request, and it defines penalties for non-compliance. So that is what they're trying to do. This is in response, like I said, these are federal regulations, but the Trump administration has said they will not enforce the 2024 federal regulations while litigation is pending. And so the author is trying to codify it. The litigation that's pending is between an entity called the ERISA Industry Committee versus the United States Department of Health and Human Services. The ERISA Industry Committee is a national advocacy organization that represents large employers that provide health, retirement, and other benefits to the workforce. And in their lawsuit, they are alleging that the federal regulation oversteps federal agencies' authority and violates the Administrative Procedures Act, the Fifth Amendment, and non-delegation doctrine. So that is all of the background. It's a pretty technical bill. I've also included in the attachment the parity final rule that kind of summarizes all of this if you want to see it in a different form, but I will open it up for discussion.
Comments from our committee? Kelly, you love the technical stuff.
This is really dense. It's wow. I'm looking.
The recommendation from staff is that they recommend that that we think about taking a support position on this.
Yeah, I can see why. And looking at the supporters for the bill, BBS does align I align with them. So I would suggest a support for the bill.
Are you suggesting or are you motioning?
Just at this point, I'm just suggesting. I'd like to hear from the other board members.
All right.
I'll just weigh in again. It's a really technical bill, and usually I wouldn't bring something so technical, but it does directly relate to mental health access and trying to break down some of the barriers, which is why I included it.
Appreciate that, Roseanne.
I
Wendy?
think I'm in the same place as Kelly. It's very dense, but inclined to go with staff recommendations.
Okay. Did you want to hear from the public before we come back and make a motion?
I think so.
Okay. Shanti.
Thanks again, Shanti Ezrin with CAMT. This is still, at this time, a watch bill for us, so no additional comments to provide.
All right, thank you. Do we have comments from our online participants?
Hi, this is the moderator. If you would like to make a comment, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are on a mobile device, you can press *3 to raise your hand. We are displaying instructions and we'll give you a moment. I see no raised hands. I return the floor back to you, Chair.
All right. So do we have a motion on the floor?
Yes, I will motion to support, and ultimately the federal law gets down to ensuring that there is parity in the way insurance companies treat mental health and substance abuse disorders and their treatment. So to that extent, that aligns with my goals as a board member. And I also see that it is supported by a number of organizations which further align with my beliefs as a board member. And so I would move to support.
Thank you, Kelly. Do you have a second? I will second. Any further discussion? All right. Christina, would you take the vote?
We have to go out to back to public.
Oh, back to public. You're right. I apologize. Shanti, any additional comments?
No, thank you very much.
Okay. How about from our online participants?
This is the moderator. We are displaying instructions if you want to make a comment on that, and we'll give you a moment. I see no comments or raised hands. I turn the floor back to you, Chair.
Thank you. Christina, would you take the vote?
Yes. Chris Jones,
Yes.
Kelly Ranasinga. I'm sorry, I didn't hear you.
Yes.
Thank you. John Sovek,
Yes.
Wendy Strack.
Yes.
Motion carries.
Wonderful. Next on the agenda is item number 13, discussion and possible action to make recommendations regarding Assembly Bill 2259, ransom, prisons, mental health. Roseanne.
Thanks, Chris. So this bill establishes a 3-year pilot program at the California Department of Corrections and Rehabilitation, or CDCR, to provide access to mental health therapy to at least 2 institutions to certain incarcerated people meeting specific criteria who are not already classified to receive mental health treatment from CDCR. The bill provides intent language that rehabilitation is an essential function of CDCR, and that the primary function of the department's mental health program is to ensure patients have ready access to mental health care based on need. And it states that access to mental health therapy should be available to all people incarcerated in CDCR, regardless of security level or sentence length, and without requiring a pre-existing mental health diagnosis. It specifies that access to these mental health therapy at these institutions shall be via virtual therapy opportunities, including confidential telehealth and telepsychiatry, or via contracted or registered mental health professionals who can provide counseling in a confidential setting. For each person, the therapy must be offered at least twice a month for at least 50 minutes or as determined by the provider. It specifies that access to these therapy services are for individuals who are currently not already classified as by the department as certain diagnosis levels that require mental health therapy. Participating incarcerated persons under this program must be within 90 days of their release date, minimum parole date, or earliest possible release date. And CDCR is also required to inform them of Medi-Cal benefits and facilitate enrollment support no less than their 90 days prior to the release date. And the coverage can be provided by Medi-Cal or another allowable funding source. It also provides that enrollment in the program cannot result in an incarcerated person as being classified as having a serious mental health disorder without a formal recommendation and without that person's written permission, and that all communications are confidential pursuant to HIPAA. And like I said, this is a pilot program, so it would sunset on July 1, 2031. The author states that currently mental health therapy services are only available to people with pre-existing diagnoses or who are placed in high acuity treatment levels, and that they are attempting to ensure that all people in our state's justice system, whether diagnosed or not, have access to the care that they need for their health and safety, and that of themselves and others. The only really analysis I have on this, or a technical comment, is possibly clarifying the allowable settings. Penal Code Section 2693A establishes the pilot program must provide incarcerated persons access to mental health therapy in 2 types of settings, either via virtual therapy opportunities, including telehealth and telepsychiatry, or via contracted, licensed, or registered mental health professionals in a confidential setting. Virtual therapy is a type of setting. It's unclear what type of setting contracted, licensed, or registered mental health providers is. I think they're trying to imply that it's an in-person setting using contracted employees versus virtual therapy. But that might also use contracted employees. So the author may wish to clarify this. This bill, a similar bill to this, very similar, also ran in 2024, AB 2142. It took a broader approach than this bill, proposing a 3-year pilot program at 2 institutions where mental health therapy would be provided to all incarcerated people. That bill died before the board was able to take a position on it. So with that, I'll open it up for discussion.
Comments from our committee? John.
So I like the idea of doing this as a pilot program with a sunset date to see, learn about it, see how effective it is, and work with that. I do have a concern about issue number 4 in your description that describes the therapeutic models that need to be used. Um, it says delivering a short-term evidence-based therapeutic model. These clients may not need short-term. I think evidence-based has multiple meanings and definitions within our community. So therapeutic models appropriate might actually be the language that would be effective. But definitely I would encourage them taking out short-term, and I would always consider reflecting on what evidence-based therapeutic model actually means in the context of this bill.
All right, thank you, Wendy or Kelly.
That was kind of my concern as well. The bill it's a little blunt, which is okay. I would just look at refining the language in accordance with Board Member Sovic, and that's it. Perhaps a supportive amended.
Are you motioning, Kelly?
Yes, I'll make that motion.
All right. Do I have a second? John.
This is John Sobeck. I'll second.
All right.
Can I summarize? So the motion is support, but support and discuss with the author about John's concerns. Is that correct? Support if amended.
Support if amended.
And also, in terms of, okay, I got the part about taking out the short term, but in terms of the evidence-based therapeutic model, I have that you have a concern about what that means, or what do you want to say about that specifically to the author?
So for me, if we were going to go ahead with this John Sobeck, the language would actually be and delivered using therapeutic model appropriate for pre-release. I would take out both short-term and evidence-based.
A therapeutic model appropriate for pre-release.
Right. So just using the language in your item number 4, but just taking out those two pieces of puzzle.
Short-term and evidence-based.
Right.
Okay. Thank you.
Any other comments from the committee before we move to the public? Okay. Shanti.
Thank you again. Shanti Ezrin with CAMT. Roseanne, thank you for the review of the bill. Thank you also for the one technical consideration that you listed in there about clarifying allowable settings. Thank you as well to the committee members for your review and your comments here. Definitely have it jotted down in my notes about taking out short-term and evidence-based from the language. So we'll definitely go back to the team with that comment and suggestion. I'll continue to share that CAMPT is co-sponsoring this bill with the Anti-Recidivism Coalition and Mental Health America of California. This bill, like Roseanne covered, is very similar to Assembly Bill 2142 that was ran in 2024, which allows access to mental health therapy to all people incarcerated in CDR settings, regardless of security level or sentence length, and without requiring a pre-existing mental health diagnosis. The main difference in this bill is just that 3-year pilot program is for 2 institutions instead of 3. So with that, would greatly appreciate the committee and board support for the bill this year. And like I said, we'll bring back those considerations to the team.
All right. Thank you, Shanti. Any comments from our online participants?
Hi, this is the moderator. We do have a comment from Dr. Lisa. You're going to be seeing an unmute request. Please click on that to make your comment. Thank you.
Dr. Lisa Weninger, LPCC. I am just grateful as a mental health clinician, but also a member of the public, that we are looking to support those at greatest need. There's an imbalance in who ends up in our criminal system, and providing mental health support right where it's truly needed is so important. I'm really grateful there's action being taken.
Thank you.
I see no other comments. I return the floor back to you.
All right, wonderful. Christina, would you take the vote, please?
Yes. John Sovek.
Yes.
Sorry, I'm rearranging it.
That's
Kelly
okay.
Ronasinghe,
Yes.
Wendy Strack,
Yes.
Chris Jones.
Yes.
Motion carries.
All right, thank you. Next on the agenda, item number 14, discussion and possible action to make recommendations regarding Assembly Bill 2345 Baines, student loans, medical, nursing, and social work students, California Healthcare Workforce Supplemental Loan Program. Roseanne.
Thanks, Chris. So this bill creates the California Healthcare Workforce Supplemental Loan Program to ensure that eligible students in medical, nursing, social work, and social welfare programs can continue accessing loan amounts comparable to the federal unsubsidized and Grad Plus loans that are being reduced under the upcoming federal changes. It authorizes the California Student Aid Commission to provide state-backed supplemental loans that fill the gap between financial aid and cost of attendance. And so just a little background on this. Starting on July 1, 2026, federal loan changes are going to create a significant funding gap for graduate students, including those that are in master's level mental health programs. They will be affected. So what's happening is that some loans called Graduate Plus loans, which students use to cover costs beyond standard federal loan amounts, will be eliminated for new borrowers, and most graduate programs will remain limited to just $20,500 per year in unsubsidized loans, with a maximum lifetime cap of $100,000, and that $100,000 includes undergraduate loans. Because many programs cost more than this, new students entering after July 1, 2026 may face substantial shortfalls and may need to rely on private loans or personal funds, and that could affect the mental health pathway and whose school is accessible to. So in terms of exactly what's going on, I've included some information from a federal website about what exactly these types of loans are, in case you're interested in great detail. And then also there was a helpful thing on UC Davis's website, kind of meant for students, that it kind of explains what's going on, that was pretty clear. So that link's included as well. But that's the background for this. So the bill would have the this loan program be under California Student Aid Commission. It requires loans under this program to have equivalent financial terms as the federal Grad Plus grant loans did, including interest rate, repayment, deferment, and forbearance. The maximum loan amount per academic year is the gap amount to ensure the student can cover the full cost of attendance not covered by federal direct unsubsidized loans or other financial aid. And it defines an eligible student, and this is the key of why we're talking about this today, as a student who's a resident of California and who's enrolled at least half-time in an accredited medical or nursing school or an accredited school of social work or social welfare program in California. They must have applied for and received the maximum federal direct unsubsidized loan amount and would have qualified for the federal Grad Plus loan under the criteria as it existed before January 20th, 2025. So the reason we're talking about this today is because some of our board license types are excluded from this. It has, when it was originally introduced, it was just medical and nursing students. Now social work and social welfare students have been included, but it does not include students in degrees intended to lead to licensure as a marriage and family therapist, educational psychologist, or professional clinical counselor. So staff is recommending a support if amended position, recommending the inclusion of postgraduate degree programs leading to licensure as an LMFT or LPCC. And also, Chris, check me if I'm wrong here, but since LEPs are a little bit different, we would have to word it differently for them. I worded it as including a postgraduate degree programs leading to credentialing as a school psychologist as well. So
yeah, that's actually perfect, because that's the only way you can become an LEP is through being a school psych first.
Yeah, I couldn't really say somebody in going to school intended to be a LEP because you have to be a school psychologist first, but you don't actually necessarily, just because you're a LEP doesn't mean that you're an active school psychologist either. So it was kind of tricky, but that's what I settled on. So anyways, I'll open it up.
No,
to
that's perfect. Yes, I agree 100%.
All right.
So,
It's
okay,
open
any
to
comments? Oh, sorry. Were you done, Roseanne? I apologize.
Go ahead.
No, I was going to ask for comments from the committee unless you had more. Okay. No, this is a big problem. This is a big problem for our profession, and so if there's a way that we can work to support, the making sure that people have access to graduate programs for mental health, then I think that's really important. So I would be in favor of supporting with amendment, if amended, to include the other 3 licenses. Do we have any other comments from the
Is that
committee?
a motion, Chris?
You know what, John? It's funny that you say that. As soon as I said it, I asked myself the same question. I'll hold my motion for a moment after I get other comments from my esteemed colleagues.
Well, I'd be happy to second your motion. I think this is going in the
Okay.
right direction. This reclassification of our profession as not being qualifying for these types of loans is seriously going to hamper our ability to have professionals in the pipeline. And I think it will cause, we're already talking about, difficulties with mental health access currently. I think the layout of this would be going on for years, and it would decimate access to mental health care in the state.
In that case, I will put my motion forward and I'll let you second it. How's that?
John Sovek, second.
Kelly, you got a comment?
I support this bill wholeheartedly. I think it's an exigent need, and I think the actions of the federal government at this level to limit graduate plus loans, which previously I don't think they had a limit, they could cover the full cost of attendance, are completely nonsensical, particularly at a time when there's an exigent mental health need. So I support it.
All right. Any further comments, Wendy? All right, let's take comments from our audience. Shanti, do you have a comment?
Yes, thank you very much. Shanti Ezrin with Camped. We are taking a very close look at this bill as well, completely in alignment with all the comments, Roseanne, that you made and that committee members made as well. Very important, this bill, especially on the heels of what the federal government is doing to cap loans for therapy and counseling master's level providers. We were very excited to see the bill and did take note that social work was added, but not therapy or counseling for the other master's level providers, Roseanne, as you mentioned. So I know our team has reached out to the author's office as to inquire on their plan to include the other master's levels, and we'll be assessing our position and advocacy efforts when we learn more. Thank you.
Wonderful, thank you. Any other comments from our online participants?
This is the moderator. Two comments. Bindu, you are first. You're going to be seeing an unmute request on your screen. Please click on that to make your comment.
Good afternoon, Bindu Makamala, Policy Manager with the NASW California, sponsor of AB 2345. And I just really appreciate everyone's comments, both board members and audience. So this bill is especially important to NASW California because access to graduate education is essential, especially in building California's future behavioral health workforce. And as mentioned before, recent federal student loan changes have threatened that pathway. So without affordable options to earn their MSW, fewer and fewer students will be able to become licensed clinical social workers at a time when our state is already facing significant provider shortages. And for many students pursuing careers in community mental health, schools, hospitals, and public service, access to financing can determine whether or not they're even able to enter the social work profession at all. And I do want to note that, for the record, we have followed the guidance of board staff on March 4th, and the NASW California directly engaged with the author's office regarding the inclusion of the social work profession and also provided relevant data. During those conversations, the author's office shared that there are some real budget and implementation considerations tied to expanding the student loan assistance programs to other professions. Yet we still strongly advocated that social workers must be part of the solution, and so we're proud to announce that social workers were ultimately included in the bill. And therefore, NASW California respectfully requests the board support of AB 2345. Thank you.
Thank you.
We have Kathy. Kathy, you're going to see an unmute request on your screen. Please click on that to make your comment.
Hi, this is Kathy Atkins from CAMT. To add on to what Shanti indicated and testified on, CAMT, just as an educational piece, CAMT is an active member of a federal coalition working on this related issue on the federal level. So that's just as a FYI. And we appreciate Roseanne spelling out the good aspects of this bill as well as the problematic. And not surprisingly, CAMT, while we haven't come out with an official position yet, obviously we'll need to advocate to ensure mental health providers, including marriage and family therapists and others under the BBS, are included as people who can continue and in their educational pathways and serve the clients of California. So, like I said, we don't have an official position, but we'll see what direction the author goes and go from there. Thank you.
Thanks, Kathy.
I see no other comments. I return the floor back to you, Chair.
All right, thank you. Christina, would you take the vote?
Yes. Wendy Strack?
Yes, you're keeping us on our toes.
I am. It's a long meeting. John Sovek?
Yes.
Kelly Ranasinga?
Yes.
Chris Jones?
Yes.
Motion carries.
All right, and with that, I think we've earned ourselves a break. Do we need 10, 15 minutes, Steve?
It has to be 15.
Well, then I guess we'll go with 15. So we'll see you all back at 1:58. We'll make it an even 2 o'clock.